Good morning, everyone. We'll go ahead and call the neighborhoods meeting to order of the Tuesday, January 20th, 2026 meeting. We'll start with introductions to my left with Mr. Delaney.
Good morning, y'all. Bill Delaney with the administration.
Brandon Russell, Council Research.
Mary Stefopoulos, Office of General Counsel.
Philip Peterson, Councilor's Office.
Michael Boylan, District 6.
Ken Amar, City Council, District 1.
Randy White, District 12.
Mike Gay, District 2.
Good morning, Chris Miller, at large, Group 5.
Ron Salem, Group 2 at large.
Good morning, Tyrona Clark Murray, District 9.
Good morning, Nick Howland, at large, Group 3, just visiting.
All right, welcome Vice President Howland, and I'd also like to recognize former council member Al Ferrara and join us in the audience today. With that, moving forward, we'll go ahead and open up for public comment. Do we have any speaker cards?
Oh, 10 minutes today.
All right, I've got one card from John J. Nooney. If you give your exact name and address for the record, and you'll be given 3 minutes to speak specifically to a item on the agenda, sir.
All right, I am John Philanthropic Jelly Roll. Good Boy Resiliency Nooney, Ocho Tres Cinco Seis, Bascom Road, Jacksonville, Florida, 32216. I'm in City Council District 4, CPAC 3, School Board District 3. And yeah, I'll be touching on agenda items 1, 2, 3. Number 4, 2025-0841, Naughton Waterways. Agenda items 5, 6, 7, 2025-0891. 12th Amendment, Better Jacksonville Plan. Anyone remember the $5 million in the private funding? Agenda item 9. Agenda item 11, 2025-0897, a new park. Is this next to a FEMA house? I digress. 1.4 million. How much is left in the Jacks Recreation Environmental Land Acquisition Fund? Is this in any way related to the Jacksonville Recreational Open Space that went back with Lori Boyer? Are we seeing an example of this with a construction project that is underway on Bowden Road and Parental Home Road in District 4? Agenda item 12, 2025-0900, 2.4 million. For it's the general fund, it's the general fund for all of us to pay. All right, agenda item 13, 2025-0004. Now, this is a special revenue and trust account. Now, this is huge. This is massive. And I'm going to be touching on that. I'm only just down to a minute 30. Agenda item 15, 16, 18, 2026-0234. What is F&B? And let's see, then we have 20. We're missing agenda item 21, 22, 23. All right, I'm only just down to a minute. So let's get back to, let's see, 23, 2025-0042, the strategic plan. Now this is, we got $10 million. Use 100 for the about CPAC 3. Okay, only 50 seconds. So I got to get back. You have to get back to 2025-0004. I'll be submitting this, for the permanent record. But again, this is huge. Ken Amaro is a sponsor. Everyone needs to be a co-sponsor. FWC, Fish and Wildlife Commission. Fishing with cash. This has everything to do with public-private partnerships. We're marketing to the world. We're marketing to the state of Florida. I'm only down to 13 seconds. Councilman Howland, again with his bill, we have the Declaration of Independence. This is the Declaration of Education, 2025-0867.
All right.
Great stuff.
Thank you, Mr. Nooney. All right, so I'd like to recognize Council President Carrico has joined us. Welcome, sir. All right, going through the agenda, we're going to go ahead and move up item number 5, 2025-0872. Can I get a motion on the bill? I've got a motion and a second. So I'm going to go ahead and turn this over to Dr. Salem and let him walk us through some presentations and get all the information to us on this bill. So Dr. Salem, you're recognized.
Thank you, Chair. I appreciate you doing that. I have a speaking engagement at noon, and this is a very important issue, and I've arranged a process to try to educate the council and the public on this issue, and it's going to take a little while, so just please bear with me. First of all, this bill was first introduced by Councilmember Arias, and he withdrew the bill. I feel strongly that the bill should be reintroduced, which I've done, and feel strongly that we fund the Kids Hope Alliance and the library, and it's appropriate for the City Council to have appointments to those boards. We will hear from the General Counsel momentarily, and he will inform you of his opinion on those appointments. This issue has come up before, as many of you know. It came up during the Jacksonville Journey discussion, and we made appointments to the Jacksonville Journey. The mayor allowed those to go through, and those appointments are still there. It came up during some of the discussions about the Meridian garbage situation, and so I would like to see this issue resolved finally one way or the other. I also have an amendment to this bill because I have been, a couple people have come up to me suggesting that I'm going to rip appointments off these boards and immediately appoint council people, and that couldn't be farther from the truth. But I do have an amendment later that will allow any appointments that are there presently to stay there, and as they roll off, if this bill does pass, then the council president will have the ability to make appointments. So I'm going to ask the General Counsel now to come up for 10 minutes to provide you his opinion on this. I have just a few questions that I'm going to raise to the General Counsel just to clarify some issues on this issue. And then Jason Teal, our legislative counsel, will provide 10 minutes of testimony. And then at that point, we will open it up for questions. So, Mr. Fackler.
Good morning. Through the chair to the committee. Thank you for the invitation, Councilman Salem. Just quick thoughts on where I think we are. This bill was introduced. I have spoken with the administration. They have authorized me to relay their position, so I will do that. If this is passed, they plan on vetoing it. If the veto is overridden, they will ask my office for a binding opinion on whether this bill conforms to the charter, at which point my office will issue a binding opinion. We have looked at this issue repeatedly, both in the Jack's Journey, as Councilman Salem mentioned. I don't remember coming up in Meridian, but that's neither here nor there. We will, before we issue a binding opinion, we will, of course, take in all the information, consider all relevant things, and issue a binding opinion if it comes to that. Our preliminary thoughts, and based on our previous research, is that we believe it likely does violate the charter. And the two provisions that we're looking at are Section 4.02 of the charter, which says all powers and duties of the consolidated government, which are legislative in nature, shall be exercised and performed by the council. All powers and duties which are executive in nature shall be exercised or performed by the mayor or such other executive officer of the consolidated government as the mayor may designate, except as otherwise specifically provided herein. The other relevant provision is Section 4.01. No power belonging to one branch of the government shall be exercised by either of the other branches, except as expressly provided in this charter. Thus, to determine whether the appointment power which this bill attempts to shift from where it is currently in the code from the executive branch to the legislative branch, we must look to whether this power is an executive power or a legislative power. The charter does not define those two terms, so we look to common usage. Merriam-Webster, I sound like a fifth grade book report. Merriam-Webster defines executive power, but it's common in the law to look at dictionary definitions. It includes the power to appoint as an executive power. When the charter was written in 1967, the power to appoint was held in the executive branch of both the state and the federal government, which gives context to the drafter's intent when they use the word executive power. The case law is consistent with that interpretation and the dictionary definition. There are a fair number of cases. I won't bore you with the whole recitation. The one that was most prevalent or easiest to find was Buckley versus Vallejo, which is a United States Supreme Court case from '76, citing to a 1928 Supreme Court case, which obviously predates the charter, talking about what is an executive function. And the 1928 case says that the power to enforce or appoint the agents charged with the duty of such enforcement is an executive power. Additionally, if this bill were to move forward and become charter, it would violate the checks and balances that we appreciate here, and as part of the separation of powers. Currently, council has a check on that appointment and that executive power in the confirmation. And this council has exercised that right several times, most recently with the Library Board of Trustees. I believe it was Ms. Anderson who did not win the approval or was not approved by this board, and therefore she was not appointed to the board. Similarly, when I was appointed, several people were propounded, and they too also did not meet with your confirmation. So you guys have a check on the executive power. She appoints, you confirm. You have to work together. In theory, you can veto every single one until you get the person that you want, but you must work together as it currently stands, which is consistent with the checks and balances inherent in our system. And if this bill passed, then there is no check and balance. Half the appointments would have no check. You guys would have 100% of that power and still exercise a check on the executive branch. So that's inconsistent with a check and balance. So in sum, we're open to discussions. We've reached out to various members, including Mr. Teal, to get discussion, to see if we're missing something, and to make sure that we're right. We will do that again if ultimately asked for a binding opinion. But it is our preliminary analysis, and I say preliminary just because it's not final, but we've looked at this issue repeatedly for different bills and so forth, and we believe that this is a violation of the charter. If there are questions, I'd be happy to take them.
Yeah, Mr. Fackrell, I'm going to raise several issues here for the committee, and if you can answer these very quickly, if you can, yes or no. I think some of them are fairly straightforward. I should also just mention these are 7-member boards. 4 the appointments in this legislation go to the mayor, 3 go to the council president. So I just want to make sure that's clear. Number one is policy making an executive power or a legislative power?
I believe the answer to the question would be probably more legislative.
Okay. In your opinion, that all appointments are executive, meaning that the legislative branch cannot make appointments to any board that it creates?
That is not my position. That is not my position. There are certain boards. First of all, the charter specifically provides the council to have certain appointments, and the charter provides that unless otherwise stated. For example, the JEA allows council to appoint. That the charter provides for that possibility, and the charter provides that exemption. There can be other boards that do purely legislative functions, such as gathering information, doing investigations. That would be a purely council function in which you, the council, would control all the appointments.
Does this hold true, this executive power, for federal boards and state boards?
Typically, I certainly have not looked at all of them, but typically, yes, the U.S. Constitution contemplates, boy, I wish I knew my articles off the top of my head, Article 2, The president does have the appointment power for officers of the United States, but that is not for all of them, certainly. There are other commissions and boards that are not necessarily appointed by the president, but typically, yes.
Is it your opinion that the council creates various boards and commissions using its legislative power, but the mayor appoints the members using her executive power?
That is that, without any context, that is my opinion.
So if the council requires that certain members of KHA, for example, are appointed by the council, it is your opinion that would violate the separation of powers under our charter?
That is my opinion preliminarily, subject, of course, we're always open to information, case law that we might have missed, other concerns. We're happy to review those.
What would be the legal effect of if the council made these appointments to boards or commissions on decisions made by those boards or commissions?
I'm not sure I follow that question. Can you repeat it for me, sir?
What would be the effect of if the council making these appointments, assuming that occurred, to a board or commission on the decisions made by those boards and commissions?
I see. So you're saying if the board is constituted in violation of the charter under this theory, what would be the effect of those opinions?
Yes,
Yeah,
decisions, and really not opinions.
The decisions, right. There's case law that suggests those are valid decisions and can't be unwound just because the potential separation of powers. And again, I would cite to Buckley versus Vallejo, which stands for that proposition. So those would be valid issues. They would be valid uses, selections of contractors, whatever the various boards or commission did.
So essentially, any decisions by the library board or KHA, if these appointments were made, would be valid decisions?
That is my opinion, yes.
Okay.
That would not be for me to decide as a side note. That would be up to a judge or someone else to decide, but there's case law that stands for that proposition.
Okay.
I haven't seen anything to the contrary.
Thank you, Mr. Teal. I'm going to ask Jason Teal to come up for 10 minutes to provide his feedback, and then we'll go to, if it's okay, then we'll have questions from the committee.
Yes, before Mr. Teal starts, I'd like to recognize Councilmember Peluso who's joined us.
Okay. Mr. Teal?
Through the chair, to the committee, Jason Teal, Legislative Counsel. So basically you heard that Mr. Fackler stated that the City Council making appointments in this regard violates the separation of powers in the charter because appointments to boards and commissions, in his opinion, is exclusively an executive power, depending on what type of board it is and what type of actions that board is allowed to take. If it's advisory to the council, then he's said that there's some latitude. But if it's not advisory, in essence, that it's applying policy, then in his opinion, that should be limited to exclusively appointments made by the executive branch. And his rationale to support that theory, as he said, starts with the dictionary definitions of executive and legislative. But the problem with stopping there is that it misses or it ignores the intent of the charter's original authors. It also simply misses or ignores the application of those terms throughout Jacksonville's 58-year history in the context of appointments to boards and commissions. The charter is silent, first of all. It makes no statement one way or the other as to who has the power to make appointments. So let's start there. So there's no prohibition in the charter against the council making appointments. There's also no provision in the charter that grants to the executive branch the exclusive right to make appointments. So in other words, making appointments is not an inalienable right under our charter. It has to be expressly granted. Now, he talked about the federal level and the state level, and Councilmember Salem, thank you for asking those questions. But what he didn't say is on the federal level, there's a provision in the U.S. Constitution called the Appointments Clause. And in the Constitution, it says that the president has the right to make appointments of all federal officers. It expressly says that. Similarly, there's a provision in the state of Florida Constitution that says the same thing for the governor of the state of Florida. So all of the case law that he's talking about is in the context and the frame of the fact that those two constitutional documents expressly give the executive the power to make appointments. Our charter does not. In fact, our charter, instead, what's in the charter demonstrates that that power does not solely belong to the mayor. Section 6.04 of the charter lists the mayor's powers. In that section, she has the power, the express power, to appoint the directors and authorize deputy directors of each department and the various division chiefs that fall within those departments. That power is given to her. Does the council have exclusive authority over those naming of those appointments to those entities? Absolutely not. The charter says that's a mayor's power. But that's where it stops. It doesn't apply that or extend that to boards and commissions that are created by the legislative branch. So that's the first section. Section 6.05 of the charter establishes the mayor's veto power. In that veto power, there are two council categories that are expressly exempt from being vetoed by the mayor. And those include appointments to the zoning board and appointments to the building codes adjustment board. So the council has exclusive right to make appointments to those two boards. The mayor can't veto it. So what it says, what it means is that if appointments under Jacksonville's charter belong only to the mayor, why are council's appointments to these two boards allowed? It doesn't make sense. It's not as clear cut as look at the definition of these two powers and what category does it fall in. So that leads me to the second point, which is Mr. Fackler's theory is also contradicted by section 50.102 of the ordinance code. So 50.102 of the ordinance code says, quote, members of the boards and commissions shall be appointed by the mayor, subject to the council, except where otherwise expressly provided with respect to a particular board or commission. That says the default is the mayor. But the city council can establish, when it creates a board or commission, who has the right to make appointments to it. Code specifically says you have that power. Now, more importantly, section 50.102 was enacted in 1973, 5 years after the consolidation. So it clearly establishes that appointments can be made by non-executive bodies and that the council, in enacting laws to create such bodies, can choose who makes their members' appointments. So I've handed out to you a spreadsheet. You should have this in front of you. I apologize for the font being small, but I tried to make it all on one page. But what this is I know. What this is this outlines or lists out the currently existing 54 boards and commissions that are in existence in the city of Jacksonville, and it identifies the name of the board or commission, the legislative authority which created the board or commission, who makes the appointments to the members of the board or commission, how many seats are on the total one, and then some notes. And in the notes, it's just when that board or commission was established. So Mr. Factor's theory on this whole thing of who makes the appointments is actually contradicted by the 58-year history of appointment powers to the city's board or commissions. So that spreadsheet, there's a few things I wanted to point out for you on this document for discussion. First, of the 54 boards and commissions, the mayor has exclusive appointment power over only 10. The city council has 33 boards that it makes appointments to, and 11 boards allow appointments from some other non-executive body. That means that the vast majority of the 54 boards and commissions are appointed by non-executive bodies, non-executive authorities. So the second thing I want to point on this document is when many of these boards were established. Now, I didn't look all of them up, but you'll notice that many of these boards are very old and some of them are very recent. Now, with particular attention, and we'll take them in order, the Building Codes Adjustment Board was established in 1969. The Board of Library Trustees was established in 1973. The Duval County Council on Elder Affairs, 1974. Construction Trades Qualifying Board, 1970. Environmental Protection Board, 1968. Jacksonville Vocational Educational Authority, 1971, and the Duval County Tourist Development Council, 1978. So when those boards I just listed off were created within the first 10 years of consolidation. Of these 7 boards, the mayor has exclusive appointing power over only 2 of the 7. Consistently, the city council also has exclusive appointing authority over 2 of the 7. So the remaining 3 are combinations of the mayor and some other non-executive body. If Mr. Fackler is right that appointments are exclusively an executive power, then that power was violated 5 out of the 7 times in the first 10 years of consolidation, when the actual intent of the drafters of the charter was fresh, it was still fresh in their minds. So to now say 58 years later that they were wrong is concerning. Now, on the flip side, 2 of those boards or commissions on that sheet were established in 2024 during Mayor Deegan's term. That is the Homelessness Initiatives Commission and the Jacksonville Journey. Both of those allow appointments by non-executive bodies. So even the recent ones allow appointments by non-executive bodies. So at this point, I'm not even sure that Mayor Deegan agrees with Mr. Fackler's interpretation of this. She allowed those boards to come into creation. So the final thing I want you to notice on this spreadsheet is where these 54 boards and commissions were established. 6 were established in the charter starting in 1971, only 3 years after consolidation. That means that the charter itself establishes 6 bodies within the consolidated city whose memberships are non-executive appointments. So according to Mr. Fackler's logic, the charter disagrees with itself, and each of these entities is unconstitutional. That makes no sense. Now, if you look at his argument about depends on what they do, we'll just focus on one of them, the Building Codes Adjustment Board. Those members are exclusively appointed by the council. It was established in 1969. The mayor has no veto power over the council's appointments per the charter. But BCAB's powers and duties include hearing appeals from decisions of the administrative official and enforcement of the building code. It hears requests from the public for variances for not having to comply with the building code. It hears appeals from decisions of the Municipal Code Compliance Division for property safety code violations. That is pure application of the law. In his definition of executive, that is executive. So this is a body that was created that applies the law that actually is only city council appointments. So the last thing, and I'll close with this, is that Mr. Fackler's opinion is not only wrong, in my opinion, it's also dangerous. Now, he's saying that 44 out of the city's 54 boards and commissions are, in essence, illegally comprised. This means that decisions by those 44 boards would now be called into question. Whether or not, there's something ultimately a court would say, those are valid decisions. The problem with it is that if I am somebody who is negatively affected by one of these boards and commissions, BCAB, Environmental Protection Board, they have the right to fine people. They have the right to force them to spend their money to correct violations on their property. Substantive rights are being impacted by decisions of these boards. If I'm somebody that comes out on the wrong end of one of those decisions, first thing I'm going to throw out there is you can't go by that decision because it was illegal. General counsel says it is. So it's troubling in that it creates a legal defense by people that are in front of all of these boards and commissions. That's dangerous for the consolidated city. The last thing is the mayor considers this bill an infringement on her power if it's passed. But the reality is the mayor never exclusively had this power to begin with. In fact, if Mr. Fackler's argument were to stand, it would infringe on the power of the council by forever taking away the council's power to make appointments. The power that the council has had since the first days of consolidation 58 years ago. Thank you, Mr. Chairman.
Thank you. At this point, Chair, I'm going to turn it back over to you for questions from the committee. As I said, I do have an amendment at the appropriate time that I want to introduce that allows all these appointments to stay on these boards until their term ends, but I'll turn it back over to you. And thank you so much for allowing this to occur this way.
All right, thank you. So let's start in the queue. We'll go with Ms. Clark Murray.
Chair, Good morning to everyone, to the chair. How many people are in your queue? Because I don't want to go first.
We can come back to you.
Please come back to me.
All right, thank you.
Thank you.
Council President Carrico.
Thank you, Mr. Chair, and good morning to all. That's a lot to unwind there, but two stark differing opinions there, one from the General Counsel, one from the Legislative Council. I guess I'd like to call the Legislative Council up and ask just a general question on when there is such a disagreement between the General Counsel and other legal opinions that guide this body, how do we determine who's right?
Through the chair to Council President. So there is a provision in the charter. So the charter outlines the powers and duties, and Mr. Fackler read you some of the provisions in section 4.02 of the charter. But there is a provision in it that says that in the event the nature of any power or duty is uncertain, or the law creating such power or duty requires a combination of branches of consolidated government, the president of the council, the mayor, and the presiding judge of the circuit court shall affix the responsibility for the exercise of such power or the performance of such duty. So if there is a determination made that we're uncertain as to who has the power to make appointments, whether it's executive, legislative, or combination of them, the charter actually says that there's a process for how you resolve those. You form this committee. In my opinion, the first question the committee should answer is it uncertain? And so assuming that they decide that yes, it's an uncertain power, then then they would. The charter says that's who, I guess, by a majority vote of the three persons on that, they would affix who has the authority to do that. So that I think would probably be the most preferred method.
All right, well, through the chair to Mr. Teal, how is it decided to take that step? Does it need to be voted on by the body as a whole? Is it just something I could determine that we need to take this in front of that committee, or is there another process for that?
So because the membership of the committee, first of all, the charter is silent as to how you trigger this. So there's a level of interpretation that needs to be made. But there is no authority for the collective body of the city council to actually say, send it to this committee. I think that any member of the committee could bring that up and could convene the committee and basically present the issue to them. And then that would, like I said, that would be the first issue that they would have to decide is, do they have jurisdiction? They only have jurisdiction if it's determined that the power to make appointments is uncertain at this point. And I think you hit the nail on the head. I think there's two competing arguments as to whether or not that's the case.
All right, thank you. And through the chair, just to be fair, Mr. Fackler, do you see it any other different way as far as how this body can determine who's right or wrong in this equation?
Through the chair to President Carrico, the thing I will add is there's a binding opinion from Judge Durden back in 68 or 69 that declares that provision unconstitutional, that it's an infringement upon the judge's ability and requires him to do something the charter can't do. I have not done a deep dive into that, but there is a binding opinion saying that that provision of uncertainty and bringing what we colloquially refer to as the head of the three families together, that provision is null and void. So we would have to look at that again, but there is a binding opinion on that. We've always interpreted that to be the role to determine uncertainty as residing in my office, whether it's uncertain or not. But in light of that binding opinion, arguably that's moot because we can't require Chief Judge Day to come participate in that three-judge panel to deal with the issue. We would, of course, take a deeper look because it's an old opinion. It says it in passing. It's not, I don't recall exactly which opinion it's in, but there is an opinion that says that provision's unconstitutional.
Okay, through the chair to Mr. Fackler, so in order to call this, maybe we have to call the heads of the families to review the opinion first. I mean, how do we determine whether that stands? It seems like we're at a loss, and maybe the best way is just handle it legislatively. We are the lawmaking body, but I'll let some other committee members ask some questions. Thank you, Mr. Chair.
All right, thank you. We'll go next to Colonel Miller.
Thank you, Mr. Chair. Through the chair, I don't have any questions, but I do want to make a couple comments based on observations and what I've taken in from the two councils who have just spoken. If I have this right, this Excel spreadsheet has 21 different times between 1968 and 2024 where there's been a dual appointing authority role for boards and commissions between the mayor and the city council. 21 times between 1968 and 2024. I have a hard time listening to statements that says if this bill that I co-sponsored, because I believe it's a good thing to do to get more representation, get a greater candidate pool where all of us represent the whole city 6 times because the voters voted for us to represent them. We can expand that candidate pool when one entity is having a rough time filling. There are other people out there available. There are lots of reasons why I think this legislation was a good thing and why I co-sponsored it. So when I hear words like, if this passes, the mayor will veto it, and then I will issue a binding opinion, it kind of makes it sound like, okay, we already know what the answer is from that side. And we've heard from Mr. Teal saying, as the council president pointed out, a very different assessment of where we are and how we got here. Very different. But to me, this precedent, and not only what Mr. Teal commented about overall of all the instances of a 58-year appointment history, but just the mere fact that 21 times from 1968 to 2024, we've had mayor and city council president appointing to boards and commissions. So why now would we take such a hard stand and say abuse of power, city council will be overstepping their power boundary given by the charter, and we've got to stop this? Why all of a sudden right now, when this very limited KHA, the Kids Hope Alliance, and the, library board, which I sit on, by the way, why now is this a huge issue, and we're already, sounds like, promising to veto and to dig in and issue a binding opinion against? I just don't get it. If we really are going to work in such a way where we're working together, the administration, city council, as we have since 1968, and representing the whole city multiple times for these boards and commissions, why all of a sudden now this is a huge issue? I just don't get it. The precedent says this is the way it does work. This is the way we should work together. And I believe this is a good piece of legislation. In fact, I think going from here, if we pass the legal hurdles, we continue to look for other opportunities to work together and duly appoint for the betterment of our city. Thank you, Mr. Chair.
All right, thank you. So we've got quite a few speakers in the queue, so we'll keep working through them. Councilmember Amaro, you're recognized.
Thank you, Mr. Chair. Mr. Teal, a couple of quick questions for you, if you please. Thank you for your explanation. I thought it was well delivered. How long have you been working at the General Counsel's office?
Through the chair to Councilmember Amaro, I started with the General Counsel's office on October 23rd of 2000. 2000.
When KHA was created in 2017, did you write the legislation?
Through the chair, no, I did not.
Okay. Was there any conversation then about the composition of the board and who makes appointments, et cetera?
Through the chair, no. I don't recall that there ever was any kind of concerns about the legal ability of the council to make these appointments.
You mentioned earlier about the statute in the charter being silent, and of course, in law, when things are silent, they can be interpreted left or right, unless there's case law or amended legislation that makes it very definitive. You said the mayor had the authority, exclusive authority to two boards. While legislation was not explicit beyond those two boards, does it also imply that that authority can extend to future boards?
Through the chair, yes. I think that the way that our city has operated for the last 58 years is that the council can decide who makes appointments to those boards. Now, I think that if it is a purely if it's an entity that falls, well, the charter says that there are definitive areas where the council cannot intrude on the mayor's ability to make appointments. That's the department heads, the division chiefs, those kinds of things. So beyond that, I think that the council does have the ability, which has been demonstrated, to name who makes appointments to the various boards and commissions.
As you went through, Chair, as you went through the historical data on appointments, is there a pattern where after nearly a decade, City Council comes back and says we need to have power to appoint on any of these bodies?
I mean, obviously, that they've been amended over the years, but I can't recall a time when there has been a shift, if you will, in the membership of any of these particular boards. Like, that it needs to be more reflective of a certain, certain entity or certain board or body or branch of government. But I think it's well within the council's rights to do that, because if the council can create the board, the council can dissolve the board in its entirety, then the council certainly has the plenary power, the inherent power to be able to establish who makes the membership.
Okay. Thank you, sir. One question for the sponsor, and I'll tell you where I am. I don't know where I am on this bill, but I remember as a reporter, I used to do restaurant reviews. And I had a meeting with one of the owners of several restaurants, and he came to me and said that you should not be reporting on restaurants. And my response to him at that time is, I don't tell you how to make hamburgers, so you don't tell me how to do news. And there's something about staying in your own lane, and I believe that. I believe that. Sometimes you stay in your own lane and you avoid collisions on the highway. To the sponsor, Mrs. Salem, why is this necessary now? Thank you, Mr. Chair.
Through the chair to Mr. Amaro, I have been a defender of the rights and the legislative ability of the city council for quite some time, and my term on the council. I was very frustrated during the Jacksonville Journey discussion, where that executive authority was mentioned. There was the same discussion about a veto of the mayor, but for reasons not clear to me, she decided to let those appointments to go through. I don't want this council or future councils not knowing if they make appointments to boards or commissions that they could be vetoed and require a vote of the council to override those, or we may have a binding legal opinion. To me, it's very clear through the presentation of Mr. Teal that we have that ability, and I think it's important that we establish it once and for all. This has not come up in the past. It's only come up recently, and I think it's important that we put this to bed, so it's very clear who can make appointments. In this case, I left 4 appointments for the mayor. I respect that. I respect her authority and the ability that she has a majority of these appointments. So I wasn't trying to change that, but I do think the council should have the ability and has the ability to make other appointments. So just want to decide this once and for all is the reason I brought this forward.
And we, as the legislative branch, still have that reserve authority that she can send appointees day in, day out, and we can reject them all.
That is true. That is true. But I want us to have the ability to make those appointments. Thank you.
All right, thank you. We'll go next to Ms. Clark Murray.
Thank you, Chair. Good morning to everyone. Mr. Fackler, if you would come back to the podium. So first of all, I heard the term issue used earlier, and I was trying to figure out what is the issue. So I said I needed to listen a little more because I'm trying to figure out, issue is kind of not necessarily a fancy word term, but it's a legal term. Let's talk about what is the problem. So I'm still trying to figure out what's the problem. But after listening for a few minutes, I think I understand what the problem is. And so it is whether or not the city council has the authority to basically appoint individuals to a particular board or commission. That seems to be the actual issue. And with that being said, you had mentioned a couple of things. My first question to you, and through the chair to Mr. Teal. Jason Teal, no, you can remain seated. Remain seated. I respect you. I actually like you. I do, because respect and like don't necessarily go along together. So please don't take this personally, because I do like you. So to Mr. Fackler, my first question is it the usual custom and standard for the legislative secretary to present or opine on legislation that's before the city council?
Through the chair to Clark Murray, I don't know the answer to that. You guys operate your internal affairs how you want to operate. I do think because Mr. Teal wears two hats, it's the council secretary. I think I might have an issue with him or her making legal arguments and acting as an advocate.
Yeah, that's kind of strange.
But he also wears the hat of legislative counsel, which is permitted under the charter 7.01. Mr. Teal may correct me, but that's to assist with the expression of legislative intent, and arguably this falls under that. My philosophy is I want to get to the right decision, so I'm certainly not going to prevent Mr. Teal from making those positions. I would definitely like him to have a seat at the table so we get to the right answer. That's the only goal that my office has, is to get to the right answer. So I'm happy to hear the other side of the argument to make sure we get it right, and I invite Mr. Teal and to sit at the table with us to make sure we get the right answer.
Okay, thank you for that. Through the chair to Mr. Fackler. You didn't mention it, but Mr. Teal did mention it, and Section 50 of our ordinance code, it does expressly state, and I'm going to read it for everyone. In regards to, so Chapter 50 is the organization of boards and commissions, and this is Part 1, and Mr. Teal did reference it. He said Section 50.102, members of boards and commissions, and I'm going to read it verbatim. General, in parentheses A, general members of the boards and commissions shall be appointed by the mayor, and that says mayor. It doesn't say Mayor Deegan. It doesn't say Mayor Curry. It says mayor. So there's no her, there's no he. It is not gender specific. I'm going to say gender neutral. So we're not talking about the current mayor. We're talking about mayors whenever, in perpetuity. Also, it says subject to confirmation by the council, except where otherwise expressly provided with respect to a particular board or commission. So, and then it continues. So that's the part that's very clear and expressly clear to me, in that we as a council, we do have that right. So I'm trying to figure out why there's even a particular issue. Now, maybe the true issue is for this particular type of board, and that this board being KHA. Maybe that's the issue. Maybe that's the, I don't know, the elephant in the room, perhaps. But Mr. Fackler, let me see if I have any other questions for you. Okay, Mr. Fackler, I do not. You may have a seat. Mr. Teal, if you would come forward, please. I don't know, I have been truly, to the chair, I have been truly pondering several things in regards to city council and just in general, especially since our last council meeting, just doing a lot of soul searching, doing a lot of thinking about what my role is here and what our role is as city council representatives. Just, I know I'm kind of digressing, but through the chair to Mr. Teal. So I'm going to go back a little ways because I was talking with, actually arguing with some of my fellow council colleagues about a land use and zoning bill. And just out of habit, I called upon you to say something, and I clearly heard in the distance, he's with legislative services. And then I was like, yeah, you know what, you're right, I forgot about that, because Mr. Teal is my go-to guy. So Mr. Teal, through the chair, what aspect of your duties, your functions under the code states that you can opine for the city council in regards to any issue? In this case, the issue being legislation.
Sure. Through the chair to Councilmember Clark Murray. First of all, I like you too. No, Mr. Fackler's correct. The charter actually allows the city council as the only entity in consolidated government to have its own independent lawyer. So I am independent of the Office of General Counsel. Now, my duties under the charter as your legislative counsel is to assist the city council with the proper formulation of policy in your legislative decisions. And so that's the role that I'm here under today, is to advise you of a counterpoint, if you will, to legal arguments that are being presented by the General Counsel's office and give you kind of as Paul Harvey used to say, the rest of the story. So, in that regard, I relied on, my history with the city and the General Counsel's office and what I've seen over the years, and an understanding of kind of how consolidation is supposed to fit together and work, and be able to exist for 58 years and function properly. So that I believe is what my role is to, in essence, give you guys the full picture to better assist you with not just the policy of the bill that's sitting in front of you, but also to think bigger picture in terms of how does your decision impact or build off of or remember the precedent that has happened in other legislative acts over the years, but also, as I tried to do, to also point out the potential dangers or pitfalls of the application of the decisions that you make. What impact will it have on the other existing 54 boards that are out there if this were to stand, and what that might mean. So I want to give you the full picture, I guess is my point.
Yeah, thank you for that. I appreciate it. And I still like you. Thank you, Mr. Teal. Through the chair to the committee. Wow. So a couple of things. Through the chair to Mr. Amaro, you asked a question, and I think you were trying to ask about the history. So KHA, was established under the former mayor, Mayor Curry. And it is a combination of the Jacksonville Children's Commission and the Jack's Journey. And during that time that it was formed, he wanted to have the ability to appoint the members of the board, and he had it during that time. And so I think that, unfortunately, the issue now is not a matter of a greater candidate pool. It's not an issue of whether or not future boards or commissions will be vetoed by the council. I'll just go ahead and say it. I think it's the fact that the mayor is currently a Democrat. That's what I think the issue is. As it stands, The legislation as it stands in regards to KHA is balanced. The mayor, she can suggest, I'll use that term, and we approve. And that's balanced. The legislation that is now before us is imbalanced. In fact, what it does is gives her, or I don't want to say her, because the mayor, because once again, it's about the mayor, the position, not an individual in that position. But the mayor will appoint 4, and we still get to approve. The council president appoints 4, and we still get to approve. Now it's imbalanced. I'm going to stop right there at this point. Okay? Thank you, Chair.
All right, thank you. So next, let's go to Councilmember Boylan.
Thank you, Mr. Chair. Just my initial comment, very brief. Just because we can, and this referenced actually 2 items on what we're speaking about today. Just because we can, should we be doing it, is my question. And then speaking to the why now, and I think Councilmember Clark Murray just spoke to that as well. I do have a couple of questions, one for Mr. Teal. Of the 54 boards on this list, how many does the council have right to confirm or deny the appointments?
I believe all of them.
So we do have a heavy hand in the process as it is today.
You do, yeah. I mean, and that's the thing too, is I wanted to mention is that just because the council has appointments doesn't mean that there's not any checks or balances. So even if it's an exclusively council appointment, other than those 2 provisions in the charter over which the mayor has veto rights or does not have veto rights, that's the check and balance, is she can veto, the council's appointments as well.
And that was my question actually to Mr. Fackler, you just pointed out, because he mentioned there is no checks and balances if the council does. But in the fact of the matter, the mayor does have the authority to it, which obviously she can veto, and then we can override if we choose to do so. So there is some balance there, with all due respect to Mr. Fackler's comment. Binding authority, Council Member, Mr. Fackler, if you wouldn't mind speaking to that. We heard I'm a little confused. You made it pretty clear that if the decision is vetoed by the mayor's office and we don't override the veto, you will have a position, you will have to make a position. You mentioned it as being a binding authority, yet you followed that up with a 3-party scenario. Could you give me clarity as to which overrides the other?
Sure. The 3-party scenario is in, I forget the charter provision, but it's in the separation of powers, and it says if the power is uncertain, then the council president, the mayor, and the chief judge of the 4th Circuit get together to allocate the power. That was referenced in our binding opinion regarding Meridian. Since that time, we have found a binding opinion from Judge Durden, who was the first general counsel, who says you can't require Judge Day in this case to be part of that. And so that provision, in his opinion, was unconstitutional, that we couldn't force it. So excising that, then it falls back to who makes the binding opinion, and that's our office's job.
And in that scenario, assuming, as you said, that the 3-party scenario doesn't work, it comes back to you. You make a decision. The council wants to challenge that decision. We're going to end up in court, invariably, with Mr. Teal defending the position of the council and you defending the position of the administration. I guess my concern is this. 55 years since the library board was established? 9 years since if it ain't broke, why try to fix it? And I do appreciate the concern and appreciate Councilman Salem's point with respect to his concern about usurping power by the administration, which I don't think is valid, but nonetheless, he says it. So I'm just really befuddled by the rationale for this and how we're spending so much time on it. But be that as it may, thank you, Mr. Fackler. As I said, I'll conclude with those words. If it ain't broke, why try and fix it? Thank you, Mr. Chair.
If I could, respond to something that Mr. Boylan said just real quick.
Yes, go ahead, sir.
For good or for evil, it would not end up in circuit court unless some third party had some rights that were infringed. Unfortunately, depending on your perspective, the final decision rests in my office. And that would be conclusion. You could not sue the mayor that was one of the driving forces behind consolidation, is to avoid those types of lawsuits. I just wanted to clarify that.
All right, thank you. We'll go next to Mr. Delaney.
Thank you. To the chair, I wanted to respond to something that Councilmember Miller said earlier, asking why now is this becoming an issue. And the answer to that is because Councilmember Salem decided to make it one with this legislation. All these loftier matters that we've been discussing aside, KHA and the Library Board have always been mayoral appointments. It's been a mayoral prerogative to make those appointments, and we simply wish to continue exercising that prerogative. There's obviously other cases where we have not had any issue with council appointments. Also, if there are specific people that council members would like to see appointed to boards, we're always open to that. I can think of two, just based on the council members sitting up here today, that we have made. We've done that in the spirit of collaboration and compromise. But that's the basic thing. That's the only reason that we're discussing this, is because this legislation got brought forward. We oppose this legislation as it is. We do intend to veto it because we see it as overreaching onto a prerogative that the mayor has, that there was evidently no issue with the last mayor or the last several mayors, in the case of the library board, having. And that's really it.
All right, thank you. Next, we'll go to Vice President Howland.
Thank you, Mr. Chair. I find this discussion fascinating. I'm glad I'm visiting today. I have a comment and then a question that hopefully Mr. Fackler could provide an answer and Mr. Teal could provide an answer. I surmise that our charter founders did not have an express appointment clause in the charter, unlike the state and unlike the U.S. Constitution, and then potentially followed up by establishing several boards with council member appointments because they understood that city council is better and more closely aligned with the interests of their different neighborhoods within the city. In fact, I'll bet you it was some kind of compromise. That might be a question for Richard Martin or Chris Ham, but I'll bet you it was some kind of compromise in the creation of the chartered government to ensure that the council had some appointment rights because they probably always more align with the interests of the specific districts. And indeed, 6 of the 9 on this dais right now are from districts, and I am pretty sure that every district member here knows their district better than the administration probably does, and than the previous administration probably did, and probably all the way through the creation of the original consolidated government. I would also surmise if you were to run a study on any composition of any board since the consolidated government, that they've become more focused on aligning certain representative has to be from this district, from this district. So the compromise of the consolidation likely was indeed trying to ensure that districts got better representations on boards and commissions. And so to that extent, I have a question for actually both Mr. Fackler and Mr. Teal. Has the city had this debate before since consolidation? Namely, has the mayor ever saw fit to challenge the city council's appointment power, either in creation of a board or changing of the composition of a board?
Through the chair to Vice President Howland, I don't know that we have. I have found memos in our file that we have reviewed that talk about the appointment powers. These seem to date from when Ms. Lacadera was general counsel, so we're talking a good ways back. And so we've definitely reviewed those, so they came up. All I can tell you is what it said on the piece of paper. I, unfortunately, was not paying that close of attention to separation of powers in my private practice 20 years ago. Of course. So I don't know. Mr. Teal might have a better answer. That's all I know.
Thank you. And same question to you, Mr. Teal. Has the city had this debate before, and do we know if the mayor's ever challenged council's appointment power and creation of a board or changing a board?
Through the chair to Council Vice President Howland. Believe it or not, consolidation happened before I was born. A couple of years. But In my years with the city general counsel's office, I'm not aware of a time when there has been the kind of pushback like this on when council has created various boards or commission to challenge their fundamental right to make appointments or to designate who shall make appointments. I will also say that in my years with the general counsel's office, I'm very familiar with the binding legal opinions, just having gone through those and looking at those on various issues over the years. And as Mr. Fackler alluded to, there isn't any that discusses this fundamental question. So, as far as I know, this is really the first time that it has ever really generated the kind of pushback when we're talking about vetoing the fundamental power of whether the council can even do this at all. Now, to Councilmember Boylan's point, I want to make sure, and to Councilmember Clark Murray, I want to make sure you understand that I'm not here to answer the question, should you do this? Is this a good idea or not about the KHA and the library board? I'm here about the can you do this? And my position is yes, you can. Should you? That's a policy call for you all to decide and make for yourselves based on whether you think it's a good idea or not, or whether this is the time is right, or whether or not this is appropriate. But that's where I want to make sure you understand I draw the line is that I'm not here to talk about whether KHA and library board should have a different appointment structure. I'm only here to answer the question does council even possess its power to begin with?
Okay. Thank you both. And final comments here in the spirit where the city and all the outlying neighborhoods collaborated to create the consolidation back in 1968. I hope that we can find a collaborative solution here. Thanks.
All right, thank you. Next, let's go to Colonel Miller.
Thank you, Mr. Chair. I just want to respond to a couple comments that were made earlier, reference some things I had said in my first time of speaking to this. But, there is nothing with my position on this, there is nothing to do with who's in the mayoral position, what party, has nothing to do with that. And you can agree or disagree with me on this, but I just say what I believe, and I will continue to do that. To me, diversity, having better representation from throughout our city, I would like to see every one of these 54 be duly appointed. I'm not picking one or another. There are two in front of us because Councilman Salem introduced this bill for the library and KHA. It could be any one of these other ones on here. And again, there are 21 on here of the 54 that are duly appointed by the mayor and city council. So again, I don't see the problem. And I get the issue of if it ain't broke, don't fix it. However, there are a lot of things that can be made better. In fact, most things can be made better. And this is one instance that I think we have an opportunity to do that. What happened with the at-large seats for city council one day? Way back when, from what I understand, most of the at-large representatives on city council were coming from Deerwood. Well, what good does it do you when you have most of your representatives on city council at-large seats coming from one neighborhood? So they saw an opportunity. Instead of saying, if it ain't broke, don't fix it, and I don't mean to slight on you, Councilman Boylan, I'm just saying, I just want to back up my position, which things can always be improved upon. And so they did that with those at-large seats. Now we have to have at-large members from throughout our entire city to represent all of our city, not just one community. So there are always opportunities to make things better. This, I see, is one step to do that. Again, of these 54, I wish they all were duly appointed by city council and the mayor. When you get one person, whether it's city council president or whether it's the mayor, appointing all of the positions for a board, what do you tend to get? I'm sorry, you can say we're going to be very diverse in where the people are coming from, what the background is, but we all have tendencies. We all kind of like certain things, and that's going to come through if only one person is appointing all the board members on a board. And as Councilmember Howland said, Vice President Howland said, you all, especially the district folks and even the at-large folks, know the individual neighborhoods better than anyone else and what they want. So I like this in concept. I'm not saying specifically only for KHA and library. I'm just saying the concept of getting more diverse, more candidates from throughout the whole city is a good thing. And we're already doing it. So to argue it's an abuse of power or a power grab or going over, making it political or going over the line, I just don't get that. That makes no sense to me. And as Councilman Vice President Howland said, let's find a way to work forward, to work together on this and represent our whole city with all of these appointments. And I think this is the way to do that. Thank you.
All right, thank you. Next, we got Dr. Salem.
Thank you, Chair. Just a couple of points. I'm astounded that we have council members that are arguing against their own powers. That's discouraging to me. But let me, Mr. Fackler, if you could come up. As I understand it, we have the authority to make a board, legislate the authority of that board, create laws that govern that board. We have the ability to remove people from those boards, yet we can't appoint people to those boards.
Through the chair to Councilman Salem, I agree with all of your powers except for the power to remove. It generally goes with the power to appoint. There might be a couple of exceptions in the code that I have not reviewed for that, but that's absolutely correct. You can create a board, you can just take it down. That's absolutely a legislative power. You can take away all of their money, absolutely. But as part of the enforcement of the laws that you create is the power to appoint the people who are going to execute the laws that you create. That's part of the executive power and the analysis that we went through.
And let me make one other point. I've had extensive discussions with Mr. Fackler on this issue. We have met one-on-one as well as with Mr. Teal. I have met with Mr. Teal on this issue one-on-one multiple times. I asked Mr. Teal to come forward today to present. I thought he would be much more effective at this than I could be. So that's why Mr. Teal is here, because I asked him to come. So with that, thank you, Mr. Chair.
All right, so we're going to go through okay, yeah, we'll call you just a second. Let me keep working through the queue here. Mr. Delaney.
If it pleases the chair, CAO Weinstein would like to make some commentary.
Thank you. Mike Weinstein, CIO. Great discussion. It's a very intellectual discussion. I think it's perfectly legitimate to discuss this when you're creating a board as to how it's to be set up and what have you. The issue here is you're taking away something the mayor already has. That's why there's not a problem. If you were creating like you are with the CBA, how you create it, who appoints, I don't think there's an issue. But basically, stepping in and taking away something mayors have had now, Curry had many others with the library, Mayor Deegan has, that's what makes it problematic.
All right, thank you. You done with Mr. Delaney? All right, very good. So we'll go to Ms. Clark Murray.
Thank you, Chair. I really won't respond to some of the comments that are made because I don't think it's necessary. I really am hoping that we can, at this point, move on, and then I guess someone's going to make an amendment. He has an amendment to his bill, and then we can discuss the specifics within the bill. So I'll just, and I was going to call Mr. Weinstein up too. That's why I was in the, one of the reasons why I was in the queue.
All right, thank you. I'd like to acknowledge Councilman Arias has joined us. And so, Mr. Salem, if you want to introduce your amendment.
My amendment is on page 4 of the bill, line 24. I think most of you have this in front of you. Adding the language, with the exception that members currently serving an unexpired term will allow to complete the remainder of their term. In no way, shape, or form am I trying to take people off these boards. I'm looking for the council president to have the ability, as people roll off, to begin making appointments. Because I was, someone suggested to me that was my intent, and that was never my intent. Thank you. If there's a second.
Okay, I've got a motion and a second on the amendment. Any discussions on the amendment? I see none. All in favor of the amendment say yea. Yea. Any opposed likewise? None. So the amendment carries. So I've got a motion and can I get a motion and a second? Second. I've got a motion and a second on the bill as amended. Ms. Murray, you're recognized.
My notes here. Once again, thank you. So, through the chair to the bill introducer, in regards to, okay, so there are two boards here. We're looking at KHA and we're looking at the Library Board of Trustees. Is there, let me see. Is there any, well, I'll just go ahead and ask. I know we've talked about the primary reason as to whether or not City Council can. Why these particular two boards, and why split up the appointments in the way that you have? And that's through the chair to the bill sponsor.
The reason I filed this legislation, I just took the legislation that Councilmember Arias had originally filed and withdrew and just reintroduced it. We have a strong mayor form of government, so I think it's appropriate that the mayor has the majority of the appointments. So that's the reason I included it as 4-3, and the reason I filed this bill, I thought it was easier. I was looking forward to the debate under Councilman Arias's introduction when he decided to withdraw it. I think this debate is useful. I enjoy it, and I think we need to settle this once and for all in terms of the executive appointments. And whether it leads to other boards or commissions, that'll be up to myself and my colleagues whether we want to change any other boards or commissions. That's not my intent presently. I'd like to see these two occur, and but I'll wait for my colleagues to do other things if they'd like to.
Thank you for that, through the chair. Thank you for that, through the chair. And so has there been any issue? I'm trying to, I know earlier we talked about the problem. I'm trying to figure out what the problem is. I know the statement was made that our power, and our being city council, is diminished. But once again, as Mr. Weinstein emphasized, the fact that this is an existing board. It's not a board that we're creating, and it has an established way to have for appointees, and they are confirmed by us. So I see the balance there. So I don't understand, and I'm not particularly fond of the phrase, because everything needs to be examined within a certain amount of time just to see if it can be tweaked or if it can be changed or made better. But I don't see how splitting the appointments makes this particular entity better. Now, what seems to be the issue with KHA is the leadership. There's I think it's a cliche, absolute power corrupts absolutely, and they don't have absolute power, but in a sense, power corrupts, So there has been just issues with those who have become the head of KHA. Now, if there was some legislation before us in determining who actually is the head and what kind of requirements for that, the qualifications for the head, I would be completely supportive of that because they're just, I don't know what happens at KHA, but it has not had a successful run of leaders. I mean, let's just face it. In the news most recently, we know the last one, she went down under some circumstances, and the one before that as well. And I think Mr. Weinstein is probably the most successful KHA leader they've had thus far. So if we had some legislation before us, and I don't know about the Board of Library Trustees, they seem to be doing an outstanding job. I don't see them in the news in a negative way. So with that, and I do appreciate past president and council member Salem. We've been getting along very well sitting next to each other here at Neighborhoods. I was like, man, when I was home, I was like, dang, we're not going to just kind of maybe put a little hiccup in our friendship here. But I can't support it because there isn't a problem to be solved. And it doesn't matter who is in the legislative branch head seat, whether it's a Democrat, Republican, it doesn't matter. It's the mayor. And I think there is an existing balance. The mayor appoints and we confirm. Or we can say, once again, nay to that person. And then whomever the mayor is can continue to suggest and we can not confirm. I think that's balanced. Thank you, Chair.
All right, thank you. Let's next go to Vice President Howland.
Thank you, Mr. Chair. I just had one more thought, and that was, I think there was a time where we did go from 7 board appointees from the mayor to 4 by council and 3 by the mayor. And I think it was while Mr. Teal was general counsel. And I think it was done by referendum with JEA in November of 2020. Mr. Teal, can you tell me, is he still here? Oh, there he is. Sorry, you were behind the monitor. Is that a precedent here, going from 7 to 4? 7 for the mayor to 3 for the mayor. In fact, we're going from 7 for the mayor to 4 to the mayor here.
Through the chair to Council Vice President Howland. Yeah, I mean, it is precedent. It is the quote-unquote taking away of the mayor's authority. Now, the vehicle for that was different because it was a charter change, whereas this is just an ordinance code change. But that charter amendment started with a bill passed by the city council calling for it to appear on the ballot. And so the council is the one that decided to put that to the voters. But yeah, that is absolutely precedent where there was a need for the membership to change in the council's opinion, and that's what prompted the legislation.
Okay, thank you.
All right, thank you. Next, let's go to Councilman Amaro.
Thank you, Mr. Chair. I'm just sitting here listening to the debate. I think that everyone has done a yeoman's job in defending their arguments for pro or con. And I'm just sitting here thinking about the political process and it reminds me of the words of Winston Churchill when he said that some people change their party because of principles and some change their principles because of the party. I'm not here to do either right now. But I am here to say that I believe in staying in your lane. And this seems like a drift out of my lane. I am comfortable with the authority that this body has in rejecting any appointment that comes forth from across the hall. I don't think we're giving that up. I think that is still with us. And this has a sensibility of almost micromanagement. It's something that I hate. I hate micromanagers. I just believe in staying in your lane. Yesterday I was in the Publix. The pharmacist was filling my pills. The guy from dairy didn't come over and tell him what to do. I just believe in staying in my lane. So right now, I'm not going to support this.
Thank you. Next, we'll go to Councilmember Bolin.
Thank you, Mr. Chair. I leaned over to my colleague here and said, "Are you going to speak?" Because I didn't want to. What he said is spot on in my view. But let me let's be pragmatic about how this is going to play out. And please know I have no political aspirations beyond this. Today, this council is not well received by the community. What's going to happen here, if this bill gets passed by the council, it's going to get vetoed by the mayor, it's going to come back to us, it's going to be a point of contention, and yet another example of where people are saying, as Councilman Amaro just mentioned, that we as a council are trying to grab power or micromanage the situation. Do we really want to put our leadership, our future leadership, in a position that they're going to be compromised in their ability to continue to serve this community on an issue like this one? As I said before, if it ain't broke, why are we trying to fix it? We have the control in this process. So I don't see the need for this bill today. And I do appreciate, Councilman Salem, I know your passion for the role of the council, and I share it in many, many respects. But as you said yourself, we have a strong form of government with the mayor as the lead of it. So let's continue the process of working in that direction. Thank you, Mr. Chair.
All right, thank you. Mr. Delaney.
Thank you, through the chair to the body. I am glad that Councilmember Howland, Council Vice President Howland, brought up JEA. That was a situation, of course, where the council did end up with more appointments, from 0 to 4 of the appointments. But that was the people that gave them that through the referendum, and that came about because of an unprecedented situation where the mayor had removed the board, installed new board members that went into the JEA sale fiasco that led to the biggest corruption case in the city's history. There was a reason for that. It was the right move to make at the time. In this case, we haven't heard that there is any issue with KHA or the library board to justify this move. We welcome the wider conversation. We enjoy participating in it, but it's going to keep getting caught up in the specifics of this bill because neither we nor apparently the sponsor have any issue with the way things are working at KHA and the library board. If you want to have the wider conversation, let's do that, but I don't see any use for this bill. We do still oppose it. We are going to veto if it were to pass. It's going to lead into lots of side tangents that we don't have to have if the goal is really to have this this wider discussion about where appointments ought to be made and by whom and how we can compromise. Thank you.
All right, thank you. We'll go to Dr. Salem. Yes, sir.
Thank you, Chair. Let me make a couple of points. Number one, when we go through the budget process, we control the purse strings. I've said that many times. We had some issues in that budget that I was adamantly opposed to, and I made the comment, once it's in the budget, it's very difficult to get it out of the budget. I lost a couple of votes on some things that I thought should not be in that budget by a couple of votes. The key is to keep it out of the budget if you don't want it in the budget. And I compare that to we have the power to vote on appointments. But once that appointment comes forward, it's difficult to reject that appointment. I want the influence of these boards to reflect the city council and or the council president at the time. That's the purpose of this. We deserve and should have our influence. It shouldn't just be one person. It should be 19 people influence policy on those boards, which is why I introduced this. Thank you, Mr. Chair.
All right, thank you, everyone, for the discussions on this. As I close this out for a vote, a few points I want to make. And Mr. Fackler, we've had our discussions, lengthy discussions in my office, and I've always told you my intent, desire is the rule of law. And that's where I'm motivated. That's the lane that I try to stay in. And looking at what Mr. Till has provided us here, so there's, looks like, you know, a lot of joint efforts here between the mayor's office and the council to appoint members on here. And so I look at this as a, you know, a sense of security that we've already established that doesn't violate the charter. And to say that, you know, we're here and don't need to make changes, well, our Constitution has always been since 1776, and we have made changes to it. And it's because of the time evolves. And so as we evolve, there's time for change. And so I believe this can get us to a better place in harmony between the two. Kind of don't like the, if you vote this in, we're automatically going to just veto it. I'd like to see some more unity here, spirit of getting reconciliation and a good working togetherness on this. So with that, let's go ahead and open the ballot and cast your vote.
Five yeas, 3 nays.
All right, by your action, you've approved 2025-0872. This takes us to our next agenda item, number 3. Okay, let me go ahead and go to the beginning of the agenda, and I'll go ahead and go through the deferrals. Item number 1, 2024-0966 will be deferred at the request of Council President Carrico. Item number 2, 2025-0361 will be deferred at the request of Councilmember White. All right, so our next action item will be item number 3, 2025-0811. Can I get a motion on the amendment? I've got a motion and a second on the amendment. Mr. Peterson.
Through the chair of the committee, the amendment will clarify where fine revenue generated under Part 3 of Chapter 462 is deposited. The majority of fines go into the general fund, but there are a few that don't, so we're just identifying that within the legislation. Striking reference to a law enforcement officer within Section 462-203C1. Law enforcement officer is already identified in that chapter. Revising Section 462-205F to reference the fines that are established in Part 18 of Chapter 462, so in case any of them do change, and there's an automatic reference back. Conforming the criteria for animal noise nuisances, there's inconsistency between how long the noise nuisance needs to go along, so we're conforming that criteria. Striking Section 462-306 from the bill, as that's not changing, so there's no reason to have it in there, and then correcting various Scribner's errors.
All right, thank you. Mr. Arias, you're on the amendment. Okay. Colonel Miller.
Yes, thanks. Through the chair, just one part of this. I have some concern, and there have been a lot of people have spoken out in public about this. I've seen a lot of emails about the concern of reducing the hold period from 6 days down to 3. Okay. All right, it's listed as amendment. Okay, you're saying 1 through 6 is what we're looking at now. Okay, my apologies. I'll pick that up after we've gone through that. I saw amends, and that's what I was looking at. Thank you.
All right, thank you. Ms. Murray.
Thank you, Chair. So, through the chair to Mr. Peterson, but I think I'm going to wind up talking with Councilmember Arias. So have those things been clarified, or we need to clarify them?
Through the chair to Councilmember Clark Murray. So our office, working with Councilmember Arias' office, working with ACPS and OGC, determined that there were some items that just need to be cleaned up. Those items 1 through 6 are all clean up to make all of Chapter 462 flow congruently from start to finish. And so that's all the amendments are doing.
Okay, all right, thank you for that. So I'm off the queue in regards to the amendment.
All right. No further discussion on the amendment. All in favor of the amendment, say aye. Aye. Any opposed likewise? None. Can I get a motion on the bill as amended? I've got a motion and a second on the bill as amended. Mr. Arias, you're recognized.
All right, thank you, Chair. I've had this bill already in the queue for several months now, maybe a couple months. Last year, I've had 4 community meetings already here at City Hall, but also some in my district at the library. This is a very passionate bill, and I want to make sure that you guys understand what we've been working on. I know that some people are in favor, some people are opposed of it. There's many different aspects to this bill. It's not just a stray hold. There's also things about like the weight of the chain that the dogs are tied to, the outside housing, the 3 walls and the shelter. So I do have, if it's okay, if you don't mind indulging me on this, I would like to call up 2 different people from the community. One would be Mr. Michael Bricker from ACPS, and then one would be Vicky as well from that she leads Lost Pets Facebook page with over 70,000 people that are really passionate about animals. That way you guys could understand what we've been working with in the last several months now to truly understand this bill. If that's okay with you, I would like to call Mr. Bricker up first.
Yes, if each one would just keep them under 5 minutes.
Okay. Yeah, and Mr. Reichert as well too has been as well, and Laura. So Mr. Reichert, go ahead.
Good morning, Richard Reichert, Administrative Services. I had a real quick comment. I just wanted to say, I wanted to assure everybody here, Mr. Chairman, and the entire board, that when we sat down and started working on these changes, our goal was just to enhance the health, wellness, and the safety of animals in the shelter. That's what this is about, and also giving our officers the flexibility when they see something that doesn't look right out in the field, that they have the ability to make a decision that's in the health, the benefit of the animal. So that's the main purpose of the work that we did here with these changes. I appreciate your support, Councilmember Arias. Thank you.
Sir. Thank you. Hi, Mr. Bricker. If you don't mind, similar to our last meeting, just kind of quick highlight, talk about the different components of this bill to the council members so they can understand what really encompasses this bill.
Sure. I'll go through the sheltering and tethering first. Those seem to be hot button items.
Name and address.
Oh, sure. Michael Bricker, address on file, Chief of Animal Care and Protective Services. So the tethering ordinance and the sheltering ordinance are 2 things that have been a hot button. Both of those things were really hard for our officers to go out and enforce. The tethering ordinance, or as people say, the chaining, required our officers to weigh both the dog and the chain at the area of the investigation, which was almost impossible. It read that the chain had to be 1/8 of the dog's weight. Now we can go there, our officers are experts in this, and say that chain is too big for this dog. We need to remove that. We're going to give you a replacement, and then we can talk about our tethering ordinance. The sheltering was much the same. As long as the dog had 3 walls, a roof, and a solid floor, they were under compliance. But that said nothing about direct sunlight or if rain was coming into the doghouse. So it could have 3 walls, a roof, and a floor, but the animal was not protected from the weather. Now with this new ordinance, they will be. And the stray hold, I think, is honestly one of the easier ones. Length of stay is something that's super important in animal shelters, but not just in animal shelters. It's very important in hospitals too. The faster you get the animals in and out of your shelter, the healthier the shelter is. And that doesn't mean that you're getting them out through euthanasia or anything like that. Our adoptions are higher than they've ever been. We're saving 87% of all the animals that come in. And any animal that is returned to owner, so that stray hold, it's getting returned within the first 3 days. So 67% of all the animals that do get returned to owners, that happens within the first 3 days. So this is an easy policy. It's nationally recognized by Best Friends Animal Society. I think they emailed all of you guys. Jacksonville Humane Society is also a big proponent of this change as well. But these are easy, common sense approaches. These are nationally recognized.
All right. Thank you, sir. So I have here a letter, a document from Laura, who she's with OGC, and I asked her in the last meeting, like, hey, how many other municipalities and cities in Florida have a 7-day, a 6-day, a 5-day, 4, 3 days, right? And so I'm just looking at some right now, right here as it is, but Leon County, Hillsborough County, which is in Tampa, Miami-Dade County, Nassau County. So Nassau's a 5-day, Clay County has no codified stray hold, Miami-Dade County is at 3 days, and St. Johns County is at 5, Broward County is at 3 days. So they're all over the place. And the state of Florida, the minimum, if I'm not mistaken, Mr. Bricker, is 3 days, correct? If you don't.
Yeah, there are a couple counties that don't have any stray hold ordinance, but of those that do, 3 days is the minimum.
And we're at 7 days as it is right
Correct.
now. So,
well, 6, sorry.
We're at 6 days. So the other part is that, people are saying, well, if the dog is after 6 days, what's going to happen? A lot of people have this misunderstanding that there'll be euthanasia. But you guys have a dog that has been there for how long? What's the longest dog you've had there?
Probably almost 2 years now. His name currently is Travis Hunter, but it used to be Hibiscus.
All right. So with Travis Hunter, for example, he's there, but he's a healthy dog.
Yeah, happy, healthy, just waiting for a family.
And are we a no-kill shelter?
So the nationally recognized number is 90%. So 90% of all animals, we're super close. We're at 88, 87, 88.
And the only way that they'll be euthanized is if they're
sick or injured. Being the animal control agency, we do take in animals that are severely injured, dangerous dogs, and those things. Those are the ones that are euthanized at our shelter.
Right. So I just wanted to make sure we clear the air that we're not, just because they're there for longer than 3 days or 6 days, we're not going to euthanize them. If they're healthy, they're going to be there, just as Travis Hunter is still there. Hopefully he gets adopted soon. So that's kind of where, from ACPS's side, if you guys, Mr. Chair, if you want to entertain and have some questions for them. If not, I don't mind calling my next group.
All right, we can go ahead and go through the queue here of the speakers. Colonel Miller.
Thank you, Mr. Chair. To the chair, to Mr. Bricker, you said that 67% of the dogs that are returned to owners are returned within 3 days, correct?
Correct.
Which that would mean that 1/3 of the dogs that get returned to owners are outside of that 3-day window.
Correct.
So
Yeah.
for every 100 dogs that come to your shelter that have owners, 33 of them, if this is enacted, may not get their dog returned to them as an owner. That's my concern. That's what I've heard others voiced. They've talked about communications, believing you're understaffed. They don't get return phone calls when they're looking for their dogs. I'm not here to point blame. I'm just saying there are things that happen in people's lives for your staff, the load that you have to take care of. I'm concerned about those owners that have been on a business trip and someone was watching their dog got away, they get back, they're outside that window, they could have been adopted out on the 4th day. And then what happens? If the owner comes back and says, that's my dog, well, someone else has adopted your dog, it's now their dog. That's my concern. I sure would want to see potentially 1/3 of the dogs that have owners that get away for some reason or get out of someone's grasp or get out the door. Certainly wouldn't want to see those go to new owners, which may love them very much, but they're not their original owners. And so that's my concern.
Very valid, if I may. Through the chair to Councilman Miller. No, we totally understand that point. And I do want to clarify that 67% of all dogs that are reclaimed in that 3 days, but only 15% of all of the dogs that come in actually get returned to owner too. So it's a very small amount. And although there is a chance that we can adopt out a dog and somebody comes in and says, that was my dog, the chance of that is very, very small. It doesn't happen often at all, and that's not something we want either. Our number one goal is to return an animal to its owner. That's the best place for it to be. We have enough animals at the shelter. We don't need another one. We want that to go home. So we've instituted a bunch of different things. We have free microchip clinics, because again, I want to mention too, if the dog comes in and it has a microchip or it has a collar with a tag, those dogs we're holding longer. We're holding the full 6 days anyway. So the stray hold doesn't change for those. So we're going to try to make contact with those people. But we also have a partnership with, it's called Petco Love Lost, which is a facial recognition software for dogs and cats. It's completely free. You can upload your pet on Petco Love Lost today. If your pet comes into our shelter or JHS, it gets matched by the picture we take versus the picture you uploaded, and we want to get that dog back to you. And we can do that ASAP, within the first 24 hours. All of our animals are put on our website immediately. As soon as they come into our location, they're put on their website for people to see. And we've also made changes in our communication channels too. So now through 630 City, if there is somebody that's on a business trip, they can put a ticket in 24 hours a day. They've always been able to do that. But now, if they say that their animal's at our shelter and they're away, they're gone, then an escalation email comes directly to all leadership of ACPS, and we answer that right away. It's now held in the same regard as like dangerous dogs, bites, cruelties, all those things. So the communication has been fixed, and then also there's so many changes to the website. Thankfully, our website's easier to read now, and we also have an app you could use. So there's a bunch of different ways for us to get that animal back. And again, that is our number one priority, is to get that animal back with its owner first.
Thank you, and thank you for all those changes. Thank you for all this work. Also for the introducer, Councilmember Arias, through the chair. Thank you for all this, because as I said on a different issue, we can always get better. We can always improve things, and you guys have taken that seriously. And everybody working together, we can affect those positive changes. My concern is, and I don't know if the introducer might have been thinking along these lines because of the concerns similar to what I just voiced. I would, if this has support, I would like to propose an amendment if the introducer isn't thinking along the same lines. I just want to make sure those voices of all those people are heard to say, if I come back on the 4th day and my dog's been adopted out, where does that put me? Well, it's somebody else's dog now, right? It's no longer my dog. If that gets adopted, my dog gets adopted out on the 4th day, and I go to the shelter on the 4th day, if this is enacted, it's no longer my dog, right?
That's correct. Similar to right now, if the 6th day, it'd be the 7th day that they could get adopted. It just doesn't happen a lot. I just want you to remember.
But you said a third of those dogs that get returned to their owners get returned after day 3.
Yep. So from 4 to 11, it drops down to 21%, and then after that, it drops down to 11%. So it is possible, but again, this is a very small number of animals, only 15% of our total number of animals. So the longer we have those animals in our shelter, the more overcrowding it is. That's when you hear about things like staffing, too many dogs in the shelter, all those things.
Thank you. And through the chair, so I do have an amendment to that effect. It's something along the lines of the dogs would be in a foster arrangement for the first 3 or 4 days after that 3-day period until whatever period, maybe it's 7 days. And then they become full-time adopted pets, because I just have some concern, even though the numbers are down and it's been voiced by a number of people. So if this gets support, I'd like to introduce that amendment for a foster care period to give people a little more time to be able to get their dogs back. And I'm sure the foster family would understand that as well. And then my last comment through the chair is, let's see, the capacity issue. You said, like Travis Hunter, who's on injured reserve right now. Yeah. That seems to be, those dogs seem to be your capacity issue, not necessarily reducing it from 7 to 3 days as far as the hold period. Those dogs that you're holding for months and years seem to be your capacity problems. What policy changes are you anticipating relating those dogs? Because, over a year, and we're concerned about dogs that are being held 7 days. So I just want to make sure I understand that, and then are there more adjustments to address that capacity issue? Thank you, Mr. Chair.
All right, thank you. Let me go to Ms. Mary.
Through the chair to Councilmember Miller, and Chief Bricker can correct me if I'm wrong, I believe fostering is a program that you all already can do. So irrespective of an amendment to provide for that opportunity, that is something that they currently can and do offer. The other thing, I just have a little bit of a concern, just thinking out loud, whenever you place a dog in a foster situation, there could be a little bit of an assumption of risk with that versus true adoption. If something were to occur with the animal while they are in the possession of the foster family, and then you get an owner that comes back. Don't know if they've ever had any issues or precedent with that, but he may be able to speak to some of that as well.
Through the chair to respond to that to Ms. Stavropoulos, I'm not sure what the correct terminology would be then, but I just believe 3 days is a little short for a number of situations for an owner who's lost their dog, who's been searching all over the city to try to get them back, and then when they finally make that contact, they find out someone else now owns your dog at day 4. So whatever that looks like that gives them a little bit more time, whether it's called adoption or whether it's called something else or foster care, I just would like an amendment to give a little more buffer time, realizing they're concerned with capacity with this bill, but still to be able to give original owners a little more time to be able to reclaim their dog. So whatever that looks like, terminology-wise, that's what I would like to propose amendment-wise.
Through the chair to Councilmember Miller, then I think you really should be considering what the length of the stray hold is. If you don't want to reduce it to 3 and you want to look at a number in the middle, Councilmember Arias referred to a couple of jurisdictions that might have 4 and 5 days, and I would point out that several of those that have the shorter period also come with a number of exceptions in some instances. But I think, and you may ask Chief Bricker if they have any recommendations on a compromise that might meet your intent, other than reduce or changing the reduction from 3 days and making it something like 4 or 5 days.
All right. Chief Bricker, you got a comment?
Richard Reichert, Administrative Services. I just wanted to make sure that we were clear that this is a small amount of animals we're talking about. We're only talking about the ones that don't have a collar and they don't have a chip. We're just talking about the small number of animals that when they come into the shelter that they don't have any way of being identified. So I just want to make sure before we make any type of amendment that we're clear on that.
Okay, what is that number then? Because you keep talking through the chair, you keep talking about capacity issue, and now you're saying it's just a small number, no big deal. I'm sorry, which is it?
Sorry. So I think what he means is a small number that are getting reclaimed. Only 15%. So 15% out of the 100, or 15 out of every 100 dogs.
Put those in numbers, if you would, not percentages, because that doesn't give me a reference or any of us to know.
Sure. So 15 animals out of every 100. Sorry. What do you mean numbers? I'm sorry.
Please, through the chair, please work with me here.
I'm trying my best.
I mean, you got to know how many dogs you have in there, how many you process, all of that. If you could just put it in context.
Sure.
No, real raw numbers in those categories that you just spoke of. Percentages doesn't help us. So, again, I apologize for stringing this out, but I just want to make sure we understand. It's either a capacity issue and you want to reduce that capacity issue, or there's a small number and it's not a big deal to reduce it to 3 days hold. It can't be both of those.
No. So let me clarify. It is a big deal to reduce it, and it is going to help with capacity. So the more animals that we get out quicker, the less capacity issues we have. At any given time right now, we have 20 to 25 dogs that are on prepay, which means they've already been pre-adopted. They're just waiting in our shelter for the rest of the stray hold to be adopted. Those could be adopted at day 3 or day 4 if we change this. So that's 3 days of additional kennel space that we would have that those dogs are not in there. That's 3 days that they don't have to be in the kennel, 3 days that they're not getting sick, 3 days that they're not having behavior issues. But as far as numbers, so intakes, we took in, let's see. This is for all of last year. We took in 3,584 total dogs. Of those dogs, 392 were returned to owner.
And do you know how many of those 392 were past the 3-day period through the chair?
Yeah, so between 4 and 11 days, 21%. 11 days plus was only 11% were return to owner.
So
I don't have those.
So over 60 some dogs went back to their owners that would have possibly been with adopted families.
Correct.
But they did get back to their owners last year.
Oh, yeah.
That under this policy potentially will not get back to their owners.
No.
So there's where I'm going with this. And so I'm just looking for a way forward that can address the real concerns of all the people who have voiced that concern. Everything else here, I think, and to the introducer, I'm going to let this go after this, I think are very good changes. This is good progress, these are good adjustments to make things better. So that's the one sticking point that if we could find a way to hear the voices and be able to find a compromise way forward there on that one issue, I think that would be great. Thank you, Chair.
All right. Let me go to Ms. Murray next.
Thank you, Chair. But Councilmember Miller went exactly where I wanted to go in regards to the distinction between those who own pets and they are in the shelter and then them being dispersed to new owners. So thank you so much for being here. But let me call Miss Vicki Nelson. If you would come on up. Yeah, and that's the primary issue that I've heard in regards to just the number of days. So I don't know how amenable the bill sponsor is to maybe lengthening those days, because that's the primary issue that I've heard. Go ahead, Ms. Nelson, if you would just say your name and your address, and then if you would talk about the issue that you have.
Okay. Vicki Nelson, I live on the south side. My address is on file. Back to the beginning of this where we discussed, where it was discussed that the editing, the major portion of this is just editing the bill. I don't know how many people have read all 20 pages of detail, and you can very well see that it's being edited, that there's multiple terms and things that are repeated multiple times, but we're taking out the minimum requirements for shelter for dogs. Like right now, the minimum requirement is 3 walls and a roof and a floor for the dogs that do have to live outside. We're eliminating that completely. There's a maximum requirement for how heavy or big a tether could be, which is what people use to tie their dog up or chain their dog up. The minimum requirement is, that wording is also being taken out, and it's being promoted as this will be easier for ACOs to, address issues that they see. The sheriff can't go give you a speeding ticket for speeding if we don't have a maximum speed limit posted, right? How are we going to enforce these laws if the minimum requirement for what the law is has been edited out of the ordinance? That part I don't understand. That's a question I have. As for the 3-day stray hold, I and another person, Karen Haight, we run Lost Pets of Jacksonville on social media. We have 85,000 members that make up citizens, local veterinarians, shelter staff, all the different rescues in town, basically a lot of animal activists in the city. And we've had this page a decade now, and what we see is that our city is just so large. We have so many people new to the area. We have so many people with language barriers. We have elderly people. We have people who don't have access to the internet or they're not internet savvy. We see every day on a daily basis, it takes 5 to 6 days minimum for people to figure out where their dogs are. The first day they run around looking in the neighborhood, asking the neighbors. The next day they say, I don't know where it went. Maybe a friend at the office sends them to our site and says, oh, your dog's posted there, whatever. But it's just not that quick of a process. And I think we're seeing amazing things happen at the shelter. And Mr. Bricker talked about all kinds of things that are happening, microchip events. He mentioned the website. Any of you right now could pull the website up on your phone, and it is not up to date. It's all things we're working on. We basically have a whole list of things that maybe Councilman Miller heard from people that regarding the communication and things like that. All these things are being worked on, but they are certainly not fixed. So to rush this doesn't make sense to me. Maybe get all these concerns that a lot of people have addressed and resolved, and then address this type of thing. We're seeing huge amounts of adoptions all under the 6-day stray hold now. So imagine what those could be if a citizen could actually call the shelter on the phone or go to the website and see updated events and programs and opportunities to see the dogs and actually communicate directly with the shelter. Because as it stands, if you lose your dog and try to call the shelter, there's no phone number, so you have to call 630-CITY. Well, they're only obviously open Monday through Friday, business hours. So after that, your only option is to get on My Jacks and put in a notice that your dog is lost. Well, we're seeing from our page, calls for service are slower than they've been in years. Maybe it's because of staffing. I don't know, but if we're not doing calls for service right now, we're certainly not going to suddenly look for messages from people looking for their lost pet regarding this amendment. And it's not the law to have your pet microchipped, so a lot of people don't have their pet microchipped. So to rush this through without at first really marketing to our citizens that microchips are important and you need to get your pet microchipped, I think we have a lot to do before we just take people's dogs away because we want to speed up an ordinance. And those same people on the pre-adoption that he mentioned, people can come in and pre-adopt a dog. And if you watch our page, you'll see if someone finds a brown dog in the neighborhood, it might get 50 comments of people saying, I'll share it, or that might be my friends. If somebody posts a cute little poodle, it will get 900 comments of people saying they want it. And those are the dogs that people rush down to the shelter and pre-adopt. Those same people that are waiting 3 days to pick them up will have no problem picking up that poodle in 6 days. I mean, they're still going to wait, but I just think we have a lot that needs to be fixed. And most of what, and I want to thank Councilman Arias for, once I reached out to him, we've held three meetings for the community to come speak, and he's been very available. He and his assistant, Evan, I think he was emailing me last night at 9:30. Like, they've been very available for anybody who wanted to reach out to them, and I appreciate that. But at all the meetings that we've had, we've just heard a lot about what we're going to do to fix all this. But we haven't really fixed anything yet. It's all in progress.
All right. Thank you, Ms. Nelson. I appreciate that. Chair, I also want to, Ms. Holly?
Good morning. My name's Holly Moulter. I'm here in regards to the 6-day stray hold currently in place and changing it to the 3-day stray hold. I am a strong advocate for the lost stray homeless dogs here in Jacksonville. I helped out regularly on the Lost Pets of Jacksonville group page for many years. I was a volunteer at Jacksonville Humane Society. I also trap and TNR community cats. I have 3 communities that I work on. I'm a pet owner. And right now, presently, I have come over to ACPS the last 3 years, and I'm a
Yes, ma'am. Excuse me, through the chair. I don't mean to interrupt. I realize that you all didn't get an opportunity to speak during the time that we did have public comment, but I really want you, which aspects of this bill do you support or do you have issues with? That's what I want you to get to.
With the 6-day, 6 to 3-day, so we have had several meetings on this, and it has finally gotten light onto the city shelter, which has been, lurking in the shadows. So we are finally getting some light onto our shelter. And we see many, many areas that need to be improved, and they are working on improving them, such as the improved website. This just got just got put up last week. Okay, so the new website is up last week. Using that website as an advocate, as a, fostering for ACPS, I am a foster. Finding those stray dogs was hard for me. So it is a new system. I'm sure it's going to be a wonderful system. It's going to update you on information for the community, for pet owners, for lost and stray dogs. But again, this was just put in place. The other area is the communication, which we all know is lacking. There was an Inspector General report out, and it's not up to par. We do have they have presented some great ideas, but we need time for these processes and implementations. We need to see how they work.
Through the chair, I'm sorry to interrupt, Ms. Molly,
Yeah.
but what I'm trying to get, what aspects of this bill do we need to continue to tweak? That's really what I'm trying to get to.
That's the 6-day to the 3-day. Cutting the 72 hours out of that is what I'm concentrated on, and this all is part of that. If a person is calling, emailing, trying to get through to the shelter to say that is my dog, and they don't get a response until a week later, you see that there is a huge issue there. So the 72 hours is huge, cutting that out from the stray hold.
So through the chair to Ms. Ballard, so what you're saying is that the time does not need to be shortened. It needs to continue to stay 6
That's right.
days.
I am against that. Yes, ma'am.
All right.
I am
Thank you.
against-
Thank you
Yes.
so much for that. And I have their information on cards here for you guys, legislative services. And I'm sorry, Ms. Ballard, my
I'm
time
done.
is up, so yes, ma'am. Thank
Okay.
you. I appreciate you.
Okay.
If
coming
you
in.
could, before you leave the podium, could you identify which organization you're with?
With me?
Yeah.
I am currently fostering for ACPS, and I advocate, and I do the dogs around Duval and the DDO program, and I am an advocate for the dogs.
Okay. And
So
your
I am
we need your address.
I reside at 12398 Brighton Bay Lane, 32246.
All right, thank you.
Yes. Uh-huh.
All right, let me go to the next speaker in the queue is Councilmember Peluso.
Thank you, Chair. And I think like many others have kind of said before me, I'm really grateful that we're talking about this, right? Animal welfare is incredibly important to a lot of my constituents. I have ACPS in my district. I have a lot of stray animals in my district. I have a lot of animal activity and need for a strong and robust animal control. I've had a really good relationship with Mr. Bricker. And also in my first week of being in City Council, I met with Denise over at the Humane Society. She was the former CEO. And one of the first things she talked to me was about how overcrowded ACPS is and how Humane Society has really taken on the brunt of a lot of folks. And she's like, a lot of changes need to be made. She listed out a bunch of them. So I'm really grateful to see that we're making some changes here. You know, I think one of the cruxes of this issue about the 3-day, 6-day. Well, first off, let me get to the outdoor shelter provision. I think that the outdoor shelter provision right now, as it stands, by giving more power to our ACPS officers is a very good thing. It gives them more ability to kind of make determinations that they should be able to make. The last I've seen, I've walked these neighborhoods and I've seen a number of animals that certainly are in a precarious situation, and I've called ACPS and they've said, hey, like the claim right now is that they've got enough shelter. So to be able to go after bad actors, and by the way, I've now, with the help of JSO, taken down 2 dog fighting pits in my district. I mean, it's a very scary thing and a very real thing in our city, and people do need to be aware of that. So I'm very supportive of that. To go from 6 days to 3 days, I mean, as I look at that provision, I look at what other counties do, especially within the Northeast Florida area. Nassau County is 3 days. I'm trying to find Clay County now. According to the website, it says 3 days. I mean, I know you're saying it, but I'm just letting you know what I just saw on their website. And obviously, state statute says 3 days is at the very least the minimum. I want to make sure dogs are able to get through the process faster. I want to make sure that we don't put them in enclosed space for too long. My dog was sitting at ACPS for, I think, about 6.5 months, and he's happy, and I love him very dearly. And I think a lot of people have kind of been lucky enough to get their dogs through ACPS. Many of you know my dog. Point being is, I don't think that movement from a 6-day to a 3-day is going to necessarily like alter in a negative way the future of our dogs and our cats. I don't have a cat. I talk a lot about dogs. And so, I mean, overall, I'm supportive of that legislation, or that piece of legislation. I trust our leadership. I want to make sure that we have as few, like, again, when we first got elected, all of us in the 23 cycle, it was super overcrowded. It was in a really bad state. To be able to give them the tools and the ability to make sure that it's not in that state with using good policy makes perfect sense to me. So I just kind of want to say that I am in support of this, and I mean, I'd like to make sure that we do know where Nassau, Clay, and St. John's are at the very least. Probably also, Baker County, and see what their stray hold provisions are, just to make sure. I do want to verify that it is 3, but that's what I found up here. But this is also something Humane Society has written us about, and has specifically said we should go to a 3-day. And so that, to me, is also a good indicator. And actually, do we have anyone here from the Humane Society? Attendance? All right. Mr. Bricker, are you able to kind of speak to, and I apologize, so if somebody brings an animal to the Humane Society, what is their interaction with ACPS at all? Like, does the Humane Society say, yep, we'll take on that dog, it's a surrendered animal or cat, and do they have their own internal policy about a hard hold, or must they go by ACPS rules and restrictions?
No, they have their own. So they unlike us, they can make that decision whether they take that animal in or not. They don't have to take in all strays. We do, so either we take them in that day or we schedule them out. But they will come to us. But yeah, they follow the same thing. So if it moves to 3 days, it'd be 3 days for them as well.
And I mean, like, that to me is also a good indicator. And by the way, Humane Society has made it their mission to make this a no-kill county. And when I met with Denise, she said, we got to make sure ACPS is in a position to make sure we are a no-kill county. We received a national recognition because of the work that we've been doing. So when I hear from Humane Society that these are changes that they want, this makes me see that this is going in the right direction. Also, Mr. Bricker has been nothing but helpful to work with. I've now had him come and do a number of we've had issues in Springfield, we've had issues in Riverside, Avondale, we've had issues in Ortega, and every time he shows up with a smile, and I know that this is a really tough, sensitive subject, but I think that we've got the right expertise on this, and I appreciate that. And knowing that we have Humane Society on board also gives me a sense of glee. And not to mention, we've got Laura, who wrote this bill, who worked for the state attorney's office. So any conversation about whether or not enforcement is able to do the action that it's doing, we've got someone who works literally in the state attorney's side of this. So I'm just letting you all know, I think enough good work was done on this. I'm very supportive of this bill, and I'd like to be a co-sponsor. Thank you.
All right, thank you. So let me go to Councilman Arias now.
All right, thank you, Chair. Just very quick, I had a question for Mr. Bricker that I don't think I got an answer for him last time. So this stray hold is for animals with no tags or microchips, meaning any animals that come in with a tag or microchip, they still will have to wait 6 days?
A minimum of 6 days, yeah.
All right, so meaning if an owner has that animal and they have a collar with a tag, that dog or cat is going to be there for 6 days. These are for animals that do not have any kind of identification. Now, my question to you is, if they come in with a collar, no tag, is that still identification, just a collar?
No, it'd have to be a tag that has information that we can research back to, or registered microchip. Yeah.
So that's one. And then the second thing is, the reason why this was obviously drafted was because of capacity issues, funding. During the budget cycle, we're looking at always, which I want to continue to support. I'm not saying we're not going to, or I'm not going to, but we're always having to give money to ACPS because they need more kennels and all that kind of stuff. This will relieve some of that, and also the feeding for the animals. So there was a couple of factors that played into why I wanted to work on this bill. But I will tell you this, that you've heard from Vicky, from Candy, and from Karen in the past, and many other advocates. They've been trying for years, since I've been on council and prior to that, to get a lot of things corrected. And so I see this bill as, even though it's kind of like both sides of the parties don't really agree to it, I think there's a lot of good that's come out of this bill in the sense of like the website, the app, the communication hopefully is starting to be worked on. the microchipping clinics. A lot of positive has started to happen now that the conversation is being held. So I just want the community to understand that whatever route this goes, I think we're definitely making strides for our babies, our animals. But the last point is that I want to bring up is two more points. I have a question for Mr. Bricker. This packet here that I gave you guys, which is what I already sent to Vicky as well too, talks about the ordinance changes and 2 letters of support, one from Best Friends and one from Humane Society. Both those letters of recommendation, you requested it from them, or did they give it to you? Like, how did they come up with those letters?
Yeah, so Jacksonville Humane Society, as Councilmember Peluso said, has been talking about a three-day stray hold for years. So once I talked to them about this and said that we're trying to move forward with this and that you were going to champion this, they were fully supportive. So they wrote the letter. Best Friends Animal Society is nationally. So when we talk about like no kill, they are the national leader in no kill. They have many articles about reducing stray hold and how that helps improve and save lives. So I reached out to them.
Okay, cool. And then my last point is what Mr. Miller's amendment was. And I feel that, I don't know if you came to one or you probably read the transcripts, but I said multiple times, and I know I said it in the last committee meeting or the last public hearing meeting, along the same line as what you just stated, Mr. Miller. I'm looking at it, if my dog escapes my house or leaves for whatever reason and the collar comes off, like, my dog is microchipped, but let's say he wasn't, we will have an issue. And I will definitely be proactive to try to find that dog right away. But sometimes people are out of town or they just don't know how to look. Whatever the case is, life happens. That's just how life is. So I wanted to have some I guess, guardrails where we still enact those 6-day stray hold while still keeping the 3-day policy. And I asked you, Mr. Bricker, can we do a temporary where if somebody adopts that animal in 3 days, they go in with the understanding like, hey, for the next 3 days, I will be quote unquote fostering this animal, and then after 3 days, it officially becomes mine. That was my question to you. Mr. Miller kind of hit on the same point. I want to be able to protect not just the animals, but also the owners of the animals, right? Because we make memories with those animals. We take them on trips. I take my dog jet skiing with me all the time. And so I want to make sure that people have a way to get back to their animals. So, and it's a true story. Go on my social media. You'll see her, all right? So I want to see if A, that's something that we could work, or B, which clearly it's a little bit of a, I guess, logistical issue, administrative issue, or B, let's meet in the middle with the community. If it's 6 days and you guys are wanting 3 days, is there a 4 or 5? Will that work? Whatever the case is, that's kind of where I'm at, because I will tell you this, the chain weight and the shelter that we talked about, those are big factors, in my opinion, that are really, in my opinion, the best parts of this bill. The stray hold is a great part too, but the other 2 parts are just as critical. So I don't want those 2 other parts to kind of just get neglected because of the stray hold. So I don't want this bill to suffer. So is there any kind of room for meeting in the middle? Because I always talk about meeting in the middle with everybody. What can you say to that?
Yeah,
through the chair.
Through the chair to Councilman Arias. Yeah, of course. I mean, any reduction in stray hold is going to save more lives. So if we can go from a 6 to a 5 or to a 4, that's going to mean more lives saved. We know by fact and by data that if it goes to 3, that's going to be our highest chance at saving the most lives. Try to get to that 90%. But if we get to a 4-day or a 5-day, yeah, that's not my number one choice, but yeah, we could definitely talk about that.
And through the chair. So I know you guys have, as Vicky stated, we've already making great strides. You guys have been working tremendously on changing not only the culture, but also the way we communicate with everybody outside. So she requested more time. Why is there a rush, right? There's still a lot of things that we're working on that have been completed, but there's still a couple more things pending. So the way I see it is, if one day we wanted to get to the 3-day stray hold, let's see how this works first, all right, while you're still working on the other aspects that she talked about, having I know that now we have a 630 city dedicated person for Humane Society, not Humane Society, Animal Care Protective Services too, not right?
No, we still the same 630 city. There's a bunch of agents over there that contact us throughout the day, but now we have an escalation email for lost dogs specifically. So if somebody says, my dog's lost, I'm on a business trip, we get that email directly.
Right. So those little things are definitely helpful. So if one day you want to get to a 3-day, I will say continue working with the community to check off everything else that they need. And in the meantime, I would just say, colleagues, come to a compromise. It's up to you guys to decide. Thank you.
Go ahead, Colonel Miller.
Yeah, through the chair, Mr. Bricker, I think, and I might have missed it if you did you comment on his, Councilmember Arias's question about where did you stand and how would you be able to exercise the option of 3 days in a foster status, and after the 6th day, it's officially, that family officially owns that stray dog. Would that work? You commented on the hold period changes, but I don't think you commented on that. Thank you. Through the chair.
Through the chair to Councilman Miller, that's exactly what we already do. So after the 3 days, if it's possible to get that animal into foster care, we try to until it's adopted. So we already try that.
No, his question was, through the chair, if a family says, I want to adopt that pet that you've posted there, would you all be able to say and administratively handle that if you let the family know there's a 3-day period, beyond those 3 days, there's a 3-day period, this dog is in a foster status with you. And after that 3-day period is up, if the original owner hasn't claimed it, after 6 days, it is officially fully your dog to own. That was the other comment that he made, asking if you could support that if that's what the body chooses.
Yes, but we already have that program. It's called Foster to Family. So if somebody pre-adopts an animal and it's there for 3 days, we give them the option to take the animal home for the rest of the stray hold, and they know that if somebody comes in during that 3 days, they have to bring the dog back to us or we're going to come get it. So we do already do that currently.
Through the chair, what I'm saying is make that officially the policy, not if they choose. Make that the policy for all adoptions. Could you support that option of, they say they want to adopt, you wait the 3 days, then they understand the next 3 days is in a foster status, and then starting on day 7, it's officially theirs. Make that a policy for all adoptions. Would you be able to support that?
So that is already the policy. We already do that currently. So we allow people to foster them. They can foster them, or they can leave the dog at our shelter for those days. That's still a 6-day stray hold. Nothing changes if we put them in foster, but there is additional risk. Once they're in foster, they still are legally our dog. But no, that wouldn't help the situation at all.
All right, thank you. Let me go to Ms. Mary real quick.
Through the chair, Mr. Miller, maybe I can assist. I think you're saying all adoptions, but I think you're still focusing on those dogs that come in on a stray hold. I think what you're getting at is it's a policy, but putting it in the code so that it's codified, not just an internal administration.
Exactly. 4 stray holds. Yes, I didn't make that distinction, but that's what I meant. And yes, versus this is what we try to do and we offer and the family does accept. Yes, that was I think that was the original question.
Sorry, so now I understand. The way Councilman Arias said there would be like a clawback of sorts. If they get adopted after that 3 days, we'd be able to get the animal back. So that's what I thought you were referring to. But yeah, I mean, we could do that, but that's still inherently just a 6-day stray hold. So it would just be easier just not to make any change to the stray hold.
But through the chair, the dog is after 3 days with another family. So it's not in the shelter at that point. So it's not taking up room in your shelter. So I'm not sure I understand you saying it's the same thing.
I understand. Well, not every family wants to do that. We'll take an animal knowing that they could possibly give we would take that animal back. And not every family wants to foster. Sometimes they're out of county. We wouldn't be able to do that if we couldn't physically get the animal back. The challenge is if they take that animal for those 3 days And then what if their phone numbers change or we can't go get the animal back? It limits the amount of people that are going to be able to do it.
Okay, through the chair, thank you. And given that response, Mr. Chair, I would recommend we go in line. I would recommend an amendment. We go in line with Nassau County, Orange County, and St. Johns County to reduce from, at this point, to a 6 to 5 day stray hold. And then we allow all those adjustments for the communications, for the other postings, systems, other changes to take place. And if we need to take just that item back up again to reduce it further, St. John's has done that previously. That would be my recommendation or recommended amendment. We go from 6 to 5 days, assuming that the introducer is okay with that.
I've got a motion and a second. Now we'll have discussion on this amendment. Mr. Boylan, are you on the amendment? Yes. Okay, go ahead.
Thank you, Mr. Chair. As a long time dog owner, 2 dogs in my house constantly for the past 26 years. I scratch my head if a dog owner doesn't have a collar, doesn't have a tag. I question whether, and who's taking care of this dog if someone is quote unquote out of town. But be that as it may, I like the 3 day. I think it's reasonable. But I appreciate your point of view. Mr. Bricker, real quick, if we made it, so there was some concern raised about your ability of your office right now to respond in a timely fashion. Is there a period of time where you're going to be more effective in doing that? And my point being this, and I offer this to Councilmember Miller, that we put it at 5 days for a specified period of time, 90 days, 120 days, or whatever it is, and then back to the 3 day, because 3 days seems to me very reasonable. But if your office is not in a position to do that, and Ms. Stefopoulos, I assume we can do that. We can make this a 5 day for a certain period of time and then take it back to the 3 day if necessary.
Through the chair to Councilmember Boylan, so yes, if you wanted to have the reduction to the 5 days as opposed to the 6
for a period
to
of
3,
time,
then you could put a proviso in the bill that that provides that provision would essentially sunset and revert back to the
3 days.
The 3 day or that it would sunset and revert to 3 days absent further action of the council. We'd have to be very careful about how we word it, and we would want to put that in the code and not just in the bill, so it's clear on the face of the code that that's the intent of the council.
But you appreciate what I'm trying to say. So, Mr. Bricker, at what point in time do you feel comfortable to say that you're going to be positioned to respond in a timely fashion to people who raise questions or concerns about their strays?
Through the chair to Councilman Boylan, I feel that we're already there. So when the issue that was raised about service calls, that's from an Inspector General report about our animal services officers not responding to running at large calls in a certain period of time, or a period of time that has nothing to do with stray hold or anything like that. We are communicating with the public. We're getting animals out and back to their owners faster than we ever have. We're doing adoptions faster than we ever have. All of our metrics are jumping in ways that they'd never have before. So.
Right. Well, thank you. Through the chair, I appreciate the intent, Councilmember Miller. I think if we've landed to 3 days, I'm comfortable in there, and the good work that Councilman Arias has done, so I'm not going to support the amendment.
All right, thank you. Let's go to Councilman Arias.
All right, thank you, sir. So obviously I can't vote on this committee, and I can't vote on the next one. I won't be able to vote at all in any committee until council night, because I think this is only going to rules and neighborhood. Mr. Stefopoulos, is that correct? Yeah, so I will tell you this. Mr. Boylan, thank you for that as well, too. My ultimate goal is just to bring this home, whether it's through an amendment, we take small steps, bringing it down from 6 to 5 days. We still have all these other great components into a bill that I definitely don't want to see be diminished because of a 3 or 5 day option. So if it's a will of the council to do 5 days, I'm on board. If it's a will of the council to do 3 days, I'm on board. Realistically, in life, I think it's all about baby steps. I like the 5 day approach, or 5 days. I will say, Mr. Miller, if you don't mind adding this to the amendment, for this to be, should this be effective and we vote on it, we take it up next week and it passes, for this to take effect in 120 days. And the reason why I say 120 days is because this will primarily affect people that do not have any kind of tags or microchips on their dogs. That way it will let Vicky and the team, everybody out there, to advocate and let people know, hey, you need to microchip your pets. Because if they end up in the shelter, they're going to be more than likely subject to this 5-day or 3-day stray hold. So we definitely need people to start microchipping. So we need to get the word out there. I know Mr. Bricker is doing an excellent job at ACPS having microchipping events, but we need more people to microchip. So I'm in favor of the 5. I just hope that somebody adds 120 days after we vote on this to take effect. Thank you.
Thank you. Ms. Murray.
Through the chair to Ms. Stefopoulos. So we need to amend the amendment, listening
Yes,
to.
through the chair, that would be an amendment to the amendment, so you could move that, and it would just be applicable to the stray hold period change. Everything else would become effective upon the effective date of the legislation. Is that the intent, Councilmember Arias? Or do you want the entire bill to become effective 128 days out?
So when I was talking about this, I was talking about the microchipping for the animals and all that, but I think that the community, I've seen it. I've already had 4. I know Vicky said 3, but I know I've definitely had 4, or maybe I'm just imagining it. But there's a lot of people out there that don't really understand what's going on. So I think the entire bill needs to be pushed to 120 days so they could actually, I'm probably going to have another meeting, and I want to make sure people understand what's going on with this. So I want to say the entire bill will be the essence.
Through the chair to Councilmember Clark Murray. So that might just be another amendment that gets offered after the Miller amendment is voted on.
Thank you. Thank you, Chair.
Okay, I don't see any other speakers in the queue on the Miller amendment. All in favor, say yea. Yea. Any opposed likewise? Okay, we got 1 nay. By your action, you've approved the amendment. Can I get a, Ms. Murray, you recognized.
Thank you, Chair. I'm in the queue to make a motion. Excuse me. Yes, to make a motion in regards to the effective date of the entire bill, and that the entire bill become effective in 120 days as opposed to upon the mayor's signature or whatever may be in the bill, the language that's currently in the bill.
Through the chair to Councilmember Clark Murray. So what we would probably do is put a provision in the code that the changes that are, or in the bill, that the changes that would be implemented would not be effective until 120 days from the effective date of the bill, because that can roll a little bit, or you can pick a date certain, but you can do it. So you can do it either way.
Thank you, Mr. Popoulos. To the chair, through the chair to the body. So I am basically so moved as Mr. Stefopoulos just said. And if you need me, I can reemphasize or restate. So basically, the bill, the entire bill, the changes to the bill will take effect. The bill will take effect 120 days after it's been voted upon, after it's been approved, and those changes.
Thank you. That makes
need a second.
That's clear to us.
Got a motion and a second. Any further discussion? Councilman Arias.
Thank you, Chair. And Mr. Popoulos, just to clarify, we take action on this next week. Let's say we vote it up and it passes. 120 days starts from there, or does it start from the mayor has 7 days to veto it if she needs to, and if not, it will start after that, I'm assuming?
Through the chair to Councilmember Arias. So you are correct. So the mayor has a 10-day period, usually up until the next council meeting. So it would be that first council meeting in February where she can return a veto. So if that date lapses, or when she signs it. So if she doesn't pursue a veto, she can sign it the day after the council meeting. It's effective upon her signature. So it would just, the 120 days, you can have it a rolling based on either when she signs it, or if she vetoes it, it would be when a veto, if it were overturned, that would be the effective date.
And through the chair, and if she doesn't sign it, but she lets the 10 days lapse, I'm assuming the 120 days starts then, at the 10-day mark.
That is correct, because the effective date language is upon her signature or without her signature.
Got it.
So
Okay.
if she doesn't return it vetoed by that next council meeting, it's effective without her signature at that point.
I'm good with that. Thank you.
All right, thank you. No other speakers in the queue. All in favor of the amendment, say aye. Aye. Any opposed likewise? No opposed. Please roll them up. Can I get a motion in the bill as amended?
Move the bill as amended.
I've got a motion and a second on the bill as amended. No speakers in the queue. Open the ballot and let's cast the vote.
Six yeas, 0 nays.
All right, by your action, you've approved 2025-0811. Thank you, everyone. Next item, number 4, 2025-0841. Can I get a motion on the amendment? I've got a motion and a second on the amendment. Mr. Peterson.
Through the chair to the committee, the amendment will clarify that the DA board can extend the performance schedule of the new performance schedule up to 6 months without further city council approval. Anything beyond those 6 months would require council approval. And then place revised agreements, amendments related to all of the MOSH agreements on file to reflect the 6-month extended performance schedule throughout all of the various agreements that are part of the larger redevelopment agreement.
All right, no discussion on the amendment. All in favor say yea. Yea. Any opposed likewise? Amendment carries. Can I get a motion on the bill as amended?
Excuse me.
Yeah, I've got a motion and a second on the amendment. Yes. Go.
Emily Pierce, 1301 River Place Boulevard, here representing MOSH, and I have our interim executive director. We were here a month ago, and we heard concerns raised by the members of this committee about reducing parking from 75 spaces to 30 spaces. So we are asking, we got back with our architects and engineers. We are going to be able to provide the 75 spaces. So we are asking that those changes be removed from this bill. So the only things that will be going forward in this bill are the performance schedule and the ability to slightly shift the areas between the three different parcel types.
All right, we'll go ahead and go to our speakers in the queue. Ms. Murray. Okay, Councilman Morrow.
Through the chair to Ms. Stepopoulos, is this the place where we introduce this requested amendment to increase the parking spaces and obliterate what's already on the document here?
Through the chair to Councilmember Morrow, yes, if you all are, I think that's Ms. Pierce's intent, is that she's asking if a member of the committee would move that as an amendment and get a second, and then you can.
I'd like to move it as an amendment.
All right, I've got a motion and a second on the amendment. Ms. Mary, you want to fully explain this amendment, or Mr. Peterson?
Through the chair to the committee, this amendment would, so the bill has brought to you reduced the parking from a minimum of 75 spaces down to a minimum of 30 spaces. This amendment would take it back up where they would be required to have that minimum of 75 spaces at the new MOSH site.
All right. Colonel Miller, are you on the amendment? Okay. All right, so I've got a motion and a second on the amendment. All in favor say yea. Yea. Any opposed? Likewise, none. Amendment carries. Yes, please roll them up. And can I get a motion and a second on the bill as amended? I've got a motion and a second on the bill as amended. Colonel Miller.
Yeah. Thank you, Mr. Chair. Through the chair, I just wanted to thank the board, Ms. Pierce, representing MOSH, and others who actually listened to us. I know there were a lot of other adjustments you all have been going through lately, leadership-wise, and other challenges. I thank you for that. I thank you for working with our body, and I think this is a much better place to be. One request through the chair I have, and not today because we've gone on a number of issues already. I would like to see, if you would, I would like to see the overall parking plan, because I know there are other things like, where do the buses park? You know, do they drop off? Do they go over here? What's the agreement with the parking garage that was discussed before? Do they pay? Where do the employees park? I understand it won't be in the 75 spaces. You know, those kinds of things. That would be, the overall parking plan would be good for us to see. Thank you very much.
Through the chair to Councilman Miller, we would be happy to meet with you. I have a sketch right now that shows the bus parking and the 75 spaces. If you'd like to see that, I'd be happy to hand that out to you right now. It doesn't address the garage and the other issues. We will be working with city parking to work on that, but I'd be happy to hand this out to you right now.
All right, thank you. Ms. Murray, you're in the queue.
Thank you, Chair. Thank you, Miss. Come back, Miss Pierce. Don't go anywhere. Come back. Thank you so much for being amenable to our concern about the parking. I just want to make sure that I know that they're in your agreement. I had an opportunity to, what we call it, skim it. And I just want to make sure, so at this point, you won't need to come back to us for any more like extensions because it's already in your agreement, correct? For the 6 months, every 6 months, like you can go back to DIA or whomever to say that you need this or that. With those 6 months, I don't want to say extensions, but extensions, do you feel like you're going to be able to start construction? Because it's scheduled for this year, right? Construction itself, March is supposed to be that day certain in regards to construction. So how are things looking in regards to the actual construction?
So we plan to break ground as required. We do have, as you pointed out, the opportunity to go to DIA for up to 6 months of extensions. We are in the process of rapidly redesigning and moving forward. We have our interim chief executive officer here with us who can speak to this a little bit more. But yes, we plan on staying on track.
Okay. All right, because there's 2028. It's like basically around the corner. So I just want to make sure. All right. Thank you so much for that. I won't belabor it with listening to you, hearing from your interim director. Sure. Thank you. Thank you, Chair.
All right, thank you. Mr. Peterson.
Through the chair, just want to add one item related to Councilmember Clark Murray's comments. This bill extends that March 1 deadline for commencing construction to September 1st. And then they have an additional 6 months they can request from DIA. So right now, if they don't request the additional extension, that they still would have to start this year, but it is not the March deadline that you brought up.
All right. No other speakers in the queue. Yeah, I've got a motion and a second on the bill as amended. Open the ballot, record your vote.
Six yeas, 0 nays.
All right, by your action, you approve 2025-0841. Next, item 5, we've already taken action. That takes us to item number 6, 2025-0890. Can I get a motion? I've got a motion and a second. No discussion. Open the ballot, record your vote.
Six yeas, 0 nays.
By your action, you approve 2025-0890. Item number 7, 2025-0891. Can I get a motion and a second on the bill? I've got a motion and a second on the bill. No speakers in the queue. Open the ballot and record your vote.
6 yeas, 0 nays.
By your action, you approve 2025-0891. Item number 8, 2025-0893. Can I get a motion and a second on the bill? I've got a motion and a second. No speakers in the queue. Open the ballot. Record your vote.
6 yeas, 0 nays.
By your action, you've approved 2025-0893. Next, item number 9, 2025-0894. Can I get a motion on the bill?
Second.
I've got a motion and a second on the bill. Ms. Murray, you're recognized.
All right. Thank you, Chair. To the committee, this is my bill, and basically it's appropriating $41,100 from a special council contingency, which is my strategic initiative dollars, however, for funding for a title report and environmental study to assess property that I'm considering for a park in my district. And that's what the funds are for. And I'll take any questions if you have any.
All right. No speakers in the queue. Open the ballot and record your vote.
6 yeas, 0 nays.
By your action, you approve 2025-0894. Item number 10, 2025-0896. Can I get a motion and a second on the bill? Second. I've got a motion and a second on the bill. Ms. Murray.
Just very quickly, Mr. Jeffries, if he's here, just very quickly, I'll ask the question as you come up. Is this a new position or is it a existing position that we're establishing with this legislation?
Through the chair to Councilman Clark Murray. This is an existing position, so the employee currently works in Community Development Block Grant. That's how it's funded, and we're just moving them to the home program, funded through admin dollars.
All right, thank you. That's all. Thank you so much. Thank you, Chair.
Thank you. No other speakers in the queue. Open the ballot, record your vote.
6 yeas, 0 nays.
By your action, you approve 2025-0896. Item number 11, 2025-0897. Can I get a motion second on the amendment? I got a motion. Can I get a second? Second. I got a second. Mr. Peterson.
Through the chair of the committee, the amendment will just correct the funding source within the bill, the specific revenue source that's within the Jack's Recreational Environmental Land Acquisition Fund, attaches a revised Exhibit 1, which is the BT, to appropriate the funds into a capital project, and then also correct the funding source within the BT. Authorize a CIP amendment and attach the appropriate CIP sheet as a new exhibit, and then correct various scriveners.
All right, thank you. So no speakers on the amendment. All in favor of the amendment say aye. Aye. Any opposed likewise? None. Amendment carries. Can I get a motion second on the bill as amended? I've got a motion second on the bill. Mr. Miller.
Thank you, Mr. Chair. I just have one question, I believe, of the auditors here. In your notes, the next to last bullet, it says seller has an active purchase and sale agreement for the subject property at a price of $1,075,000, but I see the appropriation is for $1.46 million. Could someone just help me understand that? I get the next bullet about the appraisals, but I'm just trying to understand if there was an active purchase and sale agreement for 1.075, the difference between the 1.46 and the 1.075, please.
Through the chair to Councilmember Miller, I can't explain how we got to this point. I can say that the current owner of the property is selling it to another individual. The city is buying it from that second individual at a $1.45 million price.
So for no change of time period and valuation, they're making just short of $300,000 on the transaction.
Through the chair to Councilmember Miller, the individual has had this purchase and sale agreement since January of 2025, so something that they negotiated over a year ago, but I believe the intent is for them to turn around and sell it to the city the same day that their sale goes through. So in effect, yes, but they have it. We do the purchase and sale agreement that is attached to this legislation shows that it was signed January of 2025 with those individuals.
Okay, thank you.
Thank you. While you got the microphone, Mr. Peterson, can you fully explain the amendment?
We've already voted on the amendment.
Okay. So that, what they're talking about now is nothing to okay, thank you. All right, let me go to Councilmember Amaro.
Thank you, Mr. Chair. I hear the vein of Councilmember Miller's concerns here. That again, it's one of those seem like let's make a quick buck on the city here. If just for clarification, through the chair to Mr. Peterson, Ken has an option to buy the property. He's had that since a year ago. Randy is about to buy the property from Ken, but Randy's going to turn a profit. I'm going to make some money. Is that the scenario that you just described?
Through the chair to Councilmember Amaro, I think I followed you, but yes, sir. So Ken doesn't own the property now.
Yeah.
Ken will buy the property and turn around and sell it to the city and make dollars. The city is paying the appraised value, or in between the two appraisals that the city went out and received. So one appraisal came back at $1.35 million, another one came back at $1.55 million. The city is paying, in your scenario, Ken, $1.45 million right in the middle of the two appraisals.
And I get it, but Jesus.
Chief White.
Thank you, through the chair, to help you out a little bit on this. And this area out there is a fast-growing area. This is next door to the park right there at Jones and Pritchard. And this 8.4 acres would have been developed as housing in some sort or apartments, and there's no recreation out there. And the second person would have done better than this, but agreed that we do need park space for all the growth out there. And this is, even though it's $300,000, in my eyes, it's actually a gift to have this 8.4 acres. Daryl's putting pickleball courts and things that's going to support the community that's already moved out there. So I know it looks a little funny, but actually this is, in my opinion, is a very good deal for the city to have that 8.4 acres with all the growth that's happening around it. And if Daryl wants to add something to that or not, that's about where we are. That's where we are. Thank you.
All right, no other speakers in the queue. So go ahead and, I've got a motion and a second on the bill as amended. Let's open the ballot and record your vote.
Six yeas, 0 nays.
By your action, you approve 2025-0897. Let's go to item number 12, 2025-0900. This one will be deferred at the request of the administration. So we'll bring that back. Yes, Ms. Murray, you're recognized.
Thank you, Chair. Through the chair to any representatives from United Way, I'm curious about the my sidewalks or my safe aspect of it. I think there's like 135 from private funding, and then there's 200,000 from the city. I want to know what the overall cost is. So if there's someone from United Way who can you can just email it to me. You don't need to come forward. What's the overall cost of that project? It has to do with the data portion of it. Through the chair to Mr. Delaney. Okay. All right. Thank you, Chair.
Mr. Delaney.
Thank you. Through the chair to Councilmember Clark Murray, we're happy to do so.
All right, thank you. That takes us into our second reading items. Item number 13, 2026-0004 is on second. Number 14, 2026-0005. Item 15, 2026-0031. Item 16, 2026-0032. Item 17, 2026-0035. Item 18, 2026-0034. Item 21, 2026-0036. 19, 2026-0038, 2026-0039, 22, 2026-0040, 23, 2026-0042, 24, 2026-0043, and 25, 2026-0057. Can I get a motion on the emergency? So I've got a motion and a second on the emergency. All in favor, say aye. Aye. No opposed. The bill move the bill as an emergency.
Do we have an amendment?
Move the amendment.
Move the amendment. Second.
I've got a motion and a second on the amendment. Mr. Peterson.
Through the chair of the committee, the amendment just clarify in the on-file document, the city's repayment to the developer is the leftover funds after the developer's contribution and the project is complete.
All right. Any discussion on the amendment? No discussion. All in favor, say aye. Aye. Any opposed likewise? None. So move the. I've got a motion and a second on the bill to move as an emergency as amended. And no speakers in the queue. Open a ballot, record your vote.
Six yeas, 0 nays.
All right, you have approved 2026-0057, and that is the end of our agenda, and we are adjourned.